I would call to order the Village of Westmont Planning and Zoning Commission meeting for Wednesday, June 15th, 2016. May we have a roll call, please?
Commissioner Carmichael? Here. Commissioner Sharp? Commissioner Van Buren is here. Commissioner Pill?
Here.
Commissioner Thomas?
Here.
Commissioner Bartel?
Here.
And Chairman Richard?
Here.
We have a quorum.
Okay, if you would please all rise and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. While I have you all standing, please, anybody that wants to give any testimony tonight, you've got to be sworn in. So if you'd please raise your right hand. I swear that any testimony I give this evening shall be the truth, the whole truth, and nothing but the truth, so help me God. I would request that you silence any and all electronic devices, if you would, please. First item on the agenda is the approval of the minutes of our May 18, 2016 meeting.
Motion to approve?
So moved.
Motion by Commissioner Pill, seconded by Commissioner Bartel. Question on the motion? Roll call, please.
Commissioner Van Buren votes yes. Commissioner Pill?
Yes.
Commissioner Thomas?
Yes.
Commissioner Bartel?
Yes.
Commissioner Carmichael?
Yes.
And Chairman Richard?
Yes, all right. The minutes as presented are hereby adopted and approved. Okay, ladies and gentlemen, before we start, this is not our normal meeting, so I'm going to start by explaining the procedures for this tonight's meeting. As you know, we had a public hearing for this item on May 18th. The meeting was continued at the request of the attorney for the surrounding property owners in order to present rebuttal testimony and evidence. In addition, the developer was encouraged to meet with the Homeowners Association, which we are told that this did in fact occur. The developer, I'm told, provided a revised preliminary concept plan to the village on June 14, 2016. It is my understanding that this revised plan now shows additional parking which will benefit this project, but this parking is not located on the 18-acre parcel. Otherwise, the revisions do not change the location or the size of any buildings or alter any of the proposed uses. As a result of the foregoing, I will first ask staff to provide an updated report. I will then request the developer and its team to speak and address two issues: the status of the meeting with the property owners, and two, the parking changes to the preliminary concept plan. Finally, I will then allow the public to speak and provide rebuttal testimony and evidence. Once all comments and evidence has been received, I will close a public hearing and I will ask the developer to provide closing comments. At that time, the commissioners will have their chance to ask questions. And how I intend to work this is we're going to go by commissioners one at a time. You will ask your questions, and then after all commissioners have asked their questions, we will have call it a round robin, if you would. Give us your thoughts on the questions you've heard asked and the answers provided to them. And after we have done that, then I will start to ask for motions. Now, according to this, on June the 14th, we got a revised preliminary concept plan. I would question why this happened the day before our meeting when we've got to make a decision on a very, very important project. Likewise, 5 minutes ago, I was handed this. I don't know what to make of it. I don't like having it handed to me at the last minute. I hope all of this will be explained as to what is pertained in here. Otherwise, I just don't know what to make of those couple of hundred pages. I don't have time to read them in the last 2 minutes. Okay, as per what I started out with, I would like to go with staff, if you would, please.
Thank you, Mr. Chair. I'll do a quick summary without reiterating everything that was discussed in the last meeting. The petition before you is PZ 16011, continued from the last meeting of May 18th. The petitioner proposal has for the most part, remained unchanged. It's a 60,000 square foot Olympic-sized natatorium, 7-story residential apartment building with approximately 326 units, subdivision of the 18-acre parcel into 5 smaller parcels. And as you had stated, when the staff report, which all the commissioners received, was distributed on June 10th, we had not received any changes to site plans. Those came in on June 14th. The request being made is a rezoning from the B3 to a PD overlay in the B3. The plan development request includes waiver requests to maximum floor area ratio, which is currently at 0.39 and it's requested at 0.95. Also a waiver to the minimum lot area for a multifamily residential building, which is currently deficient 46% by code. I will make a note that these were, there were 4 waivers in the last request, which have moved to, some have moved to variances, which I'll get to in a moment. With the PD agreement, it still has not yet been formalized. There have been no drafts that have been distributed or received. The special use request is for the residential development. It must substantially meet the special use standards. Particularly, staff wants to note that there is a unit mix. The number of studios, which in initial discussions was at 0, has increased to 92. This does affect the number of parking spaces required. Efficiencies require 1 parking space by code, 1 parking space per unit, whereas a 1-bedroom requires 1.5 parking spaces per unit. So the apartment mix must be solidified because there is a direct relationship with the parking variance being requested. The variance requests, which were waiver requests in the last public hearing, were to the maximum number of permitted signs in the B3 district. Currently, there's a maximum of 6. They're showing 8 new signs for a total of 13 signs. And then also there's a required off-street parking spaces waiver. There are a lot of numbers to digest with this, and I'm not going to go into all of them now. Staff can comment when the topic does come up. Initially, in the last meeting, it was 923 parking spaces deficient. Staff re-examined the classification, particularly of the natatorium, from a swimming pool to a stadium use. And essentially, it took it from a 1 per 3 persons to a 1 per 5. So we reduced that in your staff reports down to 523. There were no site changes that generated that new number. It was all administrative looking at the parking analysis. Based on the submittal that we received just Tuesday and have not had time to fully examine or distribute to engineers to look at parking space dimensions or aisle dimensions, it is currently short 476 from our code. So basically that number of 923 moved to 523 and now is at 476. The applicant is making 2 requests. One request that remains the same is that to reduce the standards for multifamily. Basically, rather than 1 per efficiency, 1.5 per 1 bedroom and 2 per 2 bedroom, they made a request that says that it should be 1 space per bedroom, regardless. And really that affects the 1-bedroom calculation of 1.5 per bedrooms. The current request is for, the current requirement is 505 spaces.
Could you repeat that, please, Joe, because I got confused there.
Okay. Current parking standards are 1 per efficiency, 1.5 for a 1-bedroom, and 2 for a 2-bedroom. The request before you is that it be 1 per 1-bedroom and 2 per 2-bedroom, and 1 per and it essentially the difference in the request is they see their request is 1 per 1-bedroom. Our requirement is 1.5 per 1-bedroom.
Okay.
So that's where the reduction in their numbers comes from is in that number there. As we did have a different unit mix in the last meeting, and I considered everything a 1-bedroom, no efficiencies, the revised requirement for the residential went from 566 to 505. And that wasn't any administrative looking at things. That is just based on a new number of 92 efficiencies. Still, as we had discussed before last year, we had just reduced our parking requirements. Before we had made that reduction, it would have required 815 spaces. They are proposing 449 spaces. That is still the same. The second request has changed somewhat. In the last request, they were asking for relief for all the natatorium parking. The current request is that there's a reevaluation of the parking for the hotel conference center golf course, which staff from the beginning has said it was set, I think, at $965, based on 2.5 per units or per rooms in the hotel. And that was to cover hotel, conference, golf course, employees, all the activities that were occurring there. When it does come up for discussion, that is the request, as they're saying, the applicant is requesting that we look at each of those uses and maybe re-examine those uses. Staff, to date, is still confident with the numbers at 2.5 to cover all those uses. And I'll go in depth in that when the time comes. What staff does want to point out is that there are some typical parking considerations when all of this is discussed, that code requires on-site parking. When all parking options are exhausted on-site, then off-site can be considered. Off-site is typically convenient, adjacent, complementary, local, and legally secured. The natatorium use is somewhat unprecedented when not located in proximity to parking such as a university. And then finally, what is also unprecedented is that the off-site parking, we've never seen something before us where the off-site parking is proposed outside of our village limits. Moving on to the next request is the preliminary concept plan. Just as a quick summary, kind of reiteration of last time is that the sidewalk access to Cass Avenue still, we haven't seen a plan that shows that. There are always opportunities for increased landscape features, architectural elements that could soften the bulk of the building. Rooftop details have not been provided. There are still questions on if the building placement is the smartest. The parking plan has been revised but not fully evaluated. The site plan now shows parking to the north of the natatorium where it was once shown as landscaped. And then there is a proposal, and as you had discussed, for some parking off Blackhawk, which will be discussed. And then there's the preliminary plat of subdivision. It has remained unchanged. It is still creation of 5 lots. Lot 1 would be the existing hotel and convention facility. Lot 2 would be shared parking. Lot 3 is the natatorium. Lot 4 is the apartment building, and Lot 5 is the west parking lot, which could be developed in the future. And then finally, public comment. We did provide all the public comments that came in after the meeting in your initial packets, which you received last week. In front of you now are all the comments that were received, I think, up until 3 o'clock today. So you have been fully updated with all the comments that we received. And as always, staff is here for questions.
Thank you very much, Joe. All right, at this time, I would ask the petitioner to present, and I would specifically ask the petitioner to cite the hardship as pertains to the 2 variances that you are requesting specifically.
Thank you, Mr. Chairman. Once again, my name is Dan Shapiro, representing the petitioner.
If I may, please, I forgot to ask everybody to, if you do come up, do we have a sign-in sheet up here?
There is one up front. There are 2 outside, and I
Okay.
think 1 has been floating around.
Okay, if you have not already signed up on the sheet outside, if you come up to speak this evening, would you please sign in at the podium so we have your signature and your name? Thank you. I'm sorry, please.
Thank you, Mr. Chairman. If it would be okay with this commission, what we'd like to do is address the parking and the other issues, and then wrap up by addressing the variance standards. I think it probably would come together a little bit easier if we could, but we want to address your question squarely. If we could just kind of talk about parking first, and then come back to that.
All right.
Thank you, Chairman, and the Planning and Zoning Commissioners. I appreciate your time this evening and certainly appreciate the roughly 5 hours that you put in at the first leg of this public hearing. Your service is certainly admirable. As you are aware, we're calling this the World-Class Westmont Project. In addition to the parking, I thought I'd give a brief, very brief recap of what the project is about and some of the key issues that are before us, and then we will also address the parking and a summary of the meeting, not only with the residents of Oak Brook Hills, but we also had a nice meeting with the Oakwood neighborhood recently as well. I did present numbers very briefly. On an inflation-adjusted basis, revenues at the resort are down 48% from their peak. Net operating income is down 84% from its peak. Hotel motel taxes, again, we are partners in the resort development to a certain degree. Hotel motel taxes are down 44%, and real estate taxation is down 64%. We discussed permitted uses last time. I want to remind everyone, yes, we've heard a lot of concern about this being a dense project. We understand that that creates a certain level of anxiety within the community. We get that. However, the proposed uses are less dense and less impactful from both a traffic perspective and a parking perspective than many uses otherwise permitted in the B3 zoning designation. So we're asking for the right to build something less dense and less impactful than what is permitted. We did look at Westmont's 2013 comprehensive plan in greater detail. And the highlights here in green: households are growing older, smaller, and more affluent. And these demographic shifts point to increasing demand for multifamily and single-family attached housing, both for sale and rental. Straight from Westmont's 2013 comprehensive plan. To clarify, there were some questions at the last public hearing about the retail component within the multifamily building at the base on the south side of the building. We're planning for roughly 12,000 square feet. This retail will be utilized by the hotel and natatorium guests, multifamily residents, and also the general public. The space will include primarily amenities to the hotel and to the apartment building, including a spa, a wine bar, a branded coffee shop, and also a car share service. And there is no risk of lease-up. That was something that was a concern last time to some of the speakers. The hotel will basically operate all of those as an adjunct facility outside of the hotel, which is something you see in many resort complexes where you have a main resort building and then several retail buildings surrounding it. So there is no risk of lease. The only thing we would not operate internally would be the car share service. However, if I couldn't lease that, I'd probably do it anyway. Brief slide here showing actual total taxation broken up and color-coded by taxing body, both 2015 actual and 2022 forecast. As you can see, there's a very large multiple there. Update since the May 18th meeting. We've increased the parking substantially after discussion with staff, and we'd like to thank both Joe and Jill for their continued efforts to make this a better project and a more friendly project. And we believe we've resolved the majority of their parking concerns. Obviously, the job is never done, with both an increased parking and also with a parking management plan. I think most of the concern is around peak events at the natatorium. We want to reiterate, that is, if we're lucky, a handful of times a year, less than 5, if we're lucky, because that will not only sell out the hotel, it will provide tremendous economic impact to the community. We did meet with the residents of Oak Brook Hills per the Planning and Zoning Commissioner's recommendation. We met with one representative from the neighborhood. We met with Mr. Day, their attorney, and Mr. Rathje, one of their consultants. Their proposal to us at the beginning of the meeting was to eliminate the apartment component entirely from the hotel parking lot, move the natatorium to the westernmost portion of the site. However, they did suggest, which is in conflict from the Plan Commission comments that we heard during the text amendment hearing, relocating the apartment building to the southwest corner of the golf course along Cass Avenue, which would require a huge amount of stormwater work, a huge site, frankly. Once we move the stormwater around, it would harm the golf course. But it also does show that they're not necessarily opposed to multifamily as a use. They're opposed to multifamily as a use in their backyard. So the previous beneficial improvements were also dismissed. We met with them early on before this project even became public, offered to bring down the tent and replace that with a permanent structure. We are planning still to do that. We are also still planning to do a 9-hole putting course to replace the cart storage building, which will go under the new meeting facility, and get rid of the tennis court, the basketball court, that type of thing, and replace it with a 9-hole putting course to improve the views, improve the sound impact, and frankly, improve the overall experience, in particular for those that are in the southwest corner of the residents of Oak Brook Hills community. That's something we've committed to do. Despite their opposition, we will be good with our word on that. As a matter of fact, we've continued with our master planning to improve the golf course with Ray Ahern, who's a noted golf course architect from Holland, Michigan. So we continue to risk capital, hoping that this gets approved, because the golf course does need quite a bit of work, and we can make it a spectacular amenity for the community. In addition, as I mentioned, we met with the Oakwood Homeowners Association. We explained the project and in detail answered any questions or concerns that they had. We agreed to assist with the dredging of Lake Charles, which is an amenity for that neighborhood. We've opened a line of communication with the community to allow them to participate in landscape design where our golf course meets their backyard. There are also some drainage issues in some of those, and we're going to address that as part of the golf course redevelopment. But some of those issues would be, right now, our fence that is owned by the golf course is currently chain link. It looks into their yard. And I said, the Oakwood also has homes that face Ogden on the south side of the Oakwood subdivision, and there's a nice solid wood fence. If that's what they want along the golf course, we will do it. And then we also, as a result of those efforts, we obtained a unanimous resolution of support from the Oakwood Homeowners Association Board of Directors. For the parking update, I'm going to turn it over to Rick Faywell, who is our architect. Louis Abuna, our parking consultant, is also here for if everyone has questions for him later. But Rick and Louis had a meeting with staff, and they can kind of walk through the development and what we've been working on. And I apologize that the update just came yesterday, but we've been working feverishly on this since the last meeting and trying to improve the plan per everyone's comments last time.
Thank you. My name is Rick Faywell. I'm the architect for the project and planner. I'll address only the parking. After the last meeting, it seemed to me like the biggest issue that was sort of unknown or uncertain, or everybody talked about and everybody was concerned about, was parking. And everybody had different numbers. They ranged from, all over the board, 1,200 to well over 2,000. So we immediately after the 18th, we sat down with Joe and Jill here and wanted to go through the parking to see what we could do to come to some kind of resolution. Because what is the right number? It behooves us to get it right as much as anybody else, because, ultimately when we run the facility, we don't want to inconvenience any of the users of any of the parts of the facility. We want it to be successful, and success, it has to be convenient for everybody. So we sat down and we talked about, what are the pieces that we thought made sense? What are the things that are in the code? What are the things that make sense today? Because things have changed over the years. Jill and Joe asked us to go out and research that a little bit with comparable hotels, comparable apartment complexes, so we did that. We came back with 10 comparable hotel facilities ranging between 0.8 to 1.5 cars per room. And it's sort of larger hotels with over 300 rooms, well over 20, 30, 40,000 square feet of meeting space. So very much comparable in size, and found that their parking ratios, like I say, 0.8 to 1.5 cars per room. So we came back with that piece of information. Louis also pulled together for the apartments that he's been involved with KLOA, same type of thing, because as you heard today, we were originally asking for 1 car per bedroom for the apartments, because that's pretty much the trend. I think his numbers came back between 0.9 for something that was a TOD to 1.2 or 3 or 4. So, we began to sort of see that 1 per bedroom might actually be fairly accurate as well. Now, in our subsequent conversations, I think we agreed that we were okay with the ultimate, studios are one bedrooms are 1.5, and 2s are 2 cars. And so 505 that Westmont's coming up, we're in agreement on. I think the biggest problem, and we also talked through the natatorium, and ultimately we came to the understanding that, okay, there are 1,200 seats. I think you all figured that there were going to be at least 200 other people there. So 1,400, 1 per 5, and we came up with a number of 280 that I think we both agreed to. So more or less, we've come down the line and agreed, per the Westmont Code, on the numbers, all except for the hotel. The hotel at 2.5 cars per room seems to us to be significantly higher than the 10 other hotels we looked at and surveyed in the community. Everything from all the way north to Wheeling, including the O'Hare products, and all the way west to Naperville. So I think that's where we still have a little bit of a concern. Now, as we were talking, staff was very helpful in sort of helping think about what are some other rationales. I think they understand the parking at Oak Brook Hills Resort probably better than anybody because they've lived with it for so long. And they know that, for instance, Parcel 5, the 104 cars immediately to the west, hasn't been used for parking in the 2 years that Peters owned the facility. So you could sort of say, well, let's take that out. You could also say, well, for larger events, we agree that we'll always be moving employee parking off-site to any one of the 4 locations that Mary Ann has procured. And I think you own some of those, or your family owns them. So that's pretty solid, even though they might be in a different community. So if we sort of agree that we move for larger events, especially, make sure that the employees 250 employees are parking off-site, that's another 250. So let's say we sort of said, okay, well, let's agree to the 965, but let's get some leeway with the 100 and the 250, and the number comes down to 615. For the hotel, restaurants, conference center, and the golfing, seems somewhat reasonable. But that would bring our total parking requirement down closer to around 1,400. And as you heard, you know, and very quickly, I'll apologize for getting the site plan done late, but what happened was internally, as we were doing this parking management plan that was requested by staff, we began to realize that we have an issue within our team about how that works, the drop-off for the natatorium and things. So we revisited that. We widened up the roadways. We created more lay-by lanes for people to drop off. That took away some parking. So as we looked at it, we began to realize there's some problems with the parking. The handicap parking, for instance, could be much more beneficial if it was actually on either side of the entry. So handicapped people are very quickly into the building and don't have to cross any roadways. That freed up some space for more parking. So we realized with those changes, 47 more spaces in the lot. That 47, plus if we sort of agree to disagree tonight and work on it and come up with a parking layout for the maintenance yard, that was another 128. So we're very quickly approaching, you know, agreement on all these parking issues with Westmont and staff. So that's more or less my explanation. It's backed up by research with, you know, comparables from other hotels, other apartments, agreement on the code issues that Westmont has that we're following along with staff. And we feel pretty confident because we want to make sure, like I said in the beginning, that we're parking it correctly as well.
I'd also like to remind everyone that when there is that big event, it's happening in the natatorium. That natatorium, well, first of all, we're going to know at least a year in advance. That event will also sell out the hotel. So the people that are in the natatorium, and we're counting parking for the natatorium, are also the people that are sleeping in the hotel. So we're counting that twice. So, you know, there should be some, you know, some positive element given for shared parking. Furthermore, it not only will sell out our hotel for the largest events, where we're the ones that we're hopeful to get and most worried about, it will also sell out, you know, several other, or you know, push demand off our property to others in the immediate area. You know, the way that works is the host hotel then works the room blocks with the event planner in other hotels, you know, first obviously within Westmont, and then, you know, others in the immediate area. Part of those contracts with those hotels will say, you will provide shuttle service to the event for the guests at your hotel that are attending the event. So that further mitigates the parking and provides us with more off-site parking when we make those deals with the other hotels in the room block for the events. I'm now going to ask Mary Ann Kaufman to come up and clarify some of the questions about the natatorium that came up at the last meeting.
Hi. My name is Mary Ann Kaufman, and I'm here to talk to you about the natatorium portion of the world-class Westmont project. If you'd like, these are the 4 questions that I was going to answer. I can stick to the traffic and congestion if that's the only one you want to hear about, or if you'd like me to answer, my talk is less than 7 minutes. Okay. I spoke at the May 18th Planning and Zoning meeting to tell you about why I was passionate about swimming and why I want to build a facility to serve the children, adults, and swim athletes of Westmont and the surrounding communities and Illinois. My daughters tell me all the time what lessons they have learned from swimming, such as time management, confident builders, goal setting, staying active and healthy, and making great friends. I believe swimming could positively impact the lives of children, adults, and athletes at every age and every skill level. At the meeting and in the weeks following, I have been asked many questions about the natatorium. Here are a few of the frequently asked questions that I have been asked. I will answer as best as I can to put minds at ease and to help you understand the synergy behind this entire project. Why aren't there similar natatoriums being developed in Illinois? We have seen a need for swim facilities in Illinois for some time. We have lived in this area since 1994, and we have considered spots in other communities and discarded the idea because of a number of complicated factors. When I was introduced to Peter by a mutual acquaintance, it became apparent that this was a situation that could actually work. One of the reasons a natatorium has not been built in Illinois is the initial cost to construct the structure. Several similar projects have been proposed in Illinois, and none have gotten off the ground, primarily because of funding. Some have sought referendums to build and run the facility, such as just as recent as Oak Park River Forest High School. District 86 in Hinsdale is currently exploring such a plan. Others look for private money and have been unsuccessful. At this time, Swim City USA in St. Charles has been working on a project for the past 3 years and has still not generated sufficient funding to proceed. St. Ignatius in Chicago has been exploring the possibility for 2 years and is now considering trying to go the nonprofit route. The Natatorium of Westmont will be fully funded by FMC Aquatics Opportunities, which is a charity sponsored by the Kaufman Family Foundation. No tax dollars will be used, no referendums will be necessary, and there will be sufficient funding to carry the project well into the future. The next reason a swim complex of this magnitude has not been built in Illinois previously is because of the staggering cost of maintaining the property, the facility, after it is built. There are costs associated with water quality, air quality temperatures, maintenance, cleaning services, repairs, and a multitude of ongoing tasks that must be performed consistently. Peter and the Oak Brook Hills already have a staff in place to perform each and every task that the natatorium would require. The charity would be able to pay a monthly facility maintenance fee, also referred to as a CAM, to Oak Brook Hills, covering all maintenance costs. Oak Brook Hills has specialized professional staff who can take care of the day-to-day problems, allowing the charity to avoid outsourcing this to more expensive contractors and avoid having to hire any additional expensive and less specialized staff. When a light bulb goes out 20 feet above in the pool area, I'll make a phone call to maintenance and have it taken care of. If a toilet overflows, the same idea. Without this type of support, maintaining a natatorium would be difficult at best. Another question that has been asked is, what are the advantages to being adjacent to the hotel and to the apartment complex? From my perspective, it is important to have the apartment complex and the hotel adjacent to the natatorium for 3 reasons. The first is it reduces the ongoing costs of maintaining the pool. This is a very important part of making sure the natatorium remains a world-class facility as years go by. Being able to share maintenance employees with the hotel and the apartment complex will make the ongoing costs of the pool more affordable, and allow for full-time, year-round reliable staff. To put it simply, the more square feet that maintenance fees are divided amongst, the more economical the costs will be. This is part of the unique opportunity of the site to enable a world-class aquatics facility like this to be built and to remain world-class for many, many years with long-term economic benefits to the village. The second reason for the apartment complex is vital is that it replaces the necessary parking spots that have been displaced by the natatorium building. The garage, which will be hidden in the middle of the apartment complex, will also provide parking for the entire development, and as designed, is visually very appealing. The third reason is that this combined complex will form a venue that has not been created anywhere else in the state of Illinois or in the Midwest. The natatorium, the luxury hotel with the facilities, the upscale apartments, and the storefronts will encourage repeat visits after the first experience, not only for swim meets, but for events such as weddings, banquets, dining, and living opportunities for many, many individuals. And the next question, which obviously is very important, won't the natatorium cause traffic and congestion? This is by far the biggest misconception. If you only hear one thing, please listen to this. There are only 6 really big swim meets annually. They are awarded on a bid basis, so it is highly unlikely we would get all 6 of them in one year. You can think of these as destination meets, where the hotel and all of its services are utilized. Peter and I are in complete agreement that the hotel will not host any other functions during these 4 to 6 meets per year because the entire facility will be needed and used for swim meet related events. For example, we will use banquet halls to feed family meals, team meals, and other activities such as off-site viewing of the meet. The hotel rooms will be filled with the families and the swimmers. This will eliminate the concerns about parking as the people staying in the hotel at that time will be the same people attending the events at the natatorium. If necessary, off-site parking and transportation have been arranged, but we really don't believe we will need it. Moreover, the largest meets in Illinois take place in November, February, and March, when the golf course is not yet being used, so there is no other demands on the parking. These meets will help to fill the hotel at an off-peak time, which provides more stable tax revenue for the village. We will always know well in advance when we are hosting a meet, and we can make the necessary arrangements when booking the hotel. There will be smaller swim meets on a more regular basis, approximately 10 per year, over weekends, concluding by 6 p.m. on Saturdays and Sundays. These are called invite meets, and attendees tend to come and go throughout that day. Usually they're in 2 or 3 separate sessions, and children swim, they participate, and then they go home. The traffic generated would be comparable to any other event that is at the hotel, such as a wedding, which we are all used to seeing cars come and go for that. And lastly, who will fund and manage the natatorium? My husband and I founded Athletico in 1991, and we have been fortunate to be able to fund our foundation and FMC Aquatic Opportunities, which will build and sustain the natatorium for years to come. Athletico will not own and manage the natatorium, and my husband and I are personally committed to see this project succeed. This is a charitable endeavor, and we are so grateful to be able to give back to the community in which we live, where we founded our business, and where we raised our children. We are excited about the prospect of bringing a world-class swim facility to Westmont. Being able to expose more people to swimming and further the sport in our state would be great. I'm just a swim mom, And all I want to see is every kid who wants to learn how to swim to have that opportunity. If you have any questions for me, I'm happy to answer them.
Thank you.
Thank you.
Thank you, Mary Ann. Great job. In conclusion, all of these ventures are being funded with local owners and private money. To reiterate a common theme here, there is no tax assistance being requested, nor will there be. There's an improvement in tourism and improvement in tax revenues to all of the taxing bodies in the community. We believe this is a great project for the community. We know it is great for the schools, and we know it is great for Westmont. Again, thank you for your time, both on May 18th and this evening, and we look forward to answering your questions shortly.
Okay, Mr. Duman, I'm still not hearing anything about a variance for signs.
The signage is really related to the natatorium requires signage. The retail components will each require a sign. However, if that's the hang-up, we'll give up on that variance. I can't believe that the signage is, for a coffee shop, for a spa, for a wine shop, a small sign above their storefront would be unreasonable for us to request. I think it's a good use. But that being said, if you don't want any signs there, we won't have the signs. We're not going to let the balance of the very positive effects of this project be derailed by some minor signage.
Well, this board needs to hear you speak as per your specific hardship, since you are asking for a variance.
I'm going to
State law
let
says
Dan
you
Shapiro,
have
our
to.
attorney, handle that.
Okay, please do.
Thank you. When we look at the issue of hardship, I think we have to look at it in the context of the project and what was asked. So specifically, if you look at hardship in the context of parking, the context of that context is no longer such a big issue in terms of hardship as it was, say, a month ago. Why? Because we've provided some answers to staff's questions. We were challenged by this commission, we were challenged by staff to do our homework, to find other comparables, residential developments, and to find other similar hotel developments. And we did that. And as Rick very, very clearly explained, if you look at what we have done both on-site with the addition of the 110 spaces, with staff's adjustment on the natatorium spaces, with the provision of 250 spaces off-site for employees, the number of that hardship is now significantly decreased, if any. That takes me to the issue of the maintenance. We'll call it the maintenance lot. We understand that there's work to do there. We understand that there's more examination to do there. We offer that kind of as a reserve lot, that if through further discussions with staff, the board, or this commission if necessary, that lot becomes available, we now have even more parking. So if we don't include that parking, that 120 odd spaces, and you look at the off-site parking, then there is no hardship because there's no need for a variance for a parking request. And if there's no need for a variance, then there's no hardship because we've satisfied the parking criteria. But if you take everything, if you take the off-site away, if you take the 122 away, if, for example, a staff looks at the adjustment of additional 40-odd spaces on the site plan, and all of staff's arguments and our arguments fall that way, then the hardship is very simple. If we don't get, the hardship is we need your help in granting the variance for parking I'm talking about right now, because without it, the project fails. Simple as can be. Because then we can't accommodate all of the cars. We can't accommodate all of the needs. Now, maybe I'm a little dramatic in saying the project fails, but I would say it becomes extraordinarily hard if you look at all of the uses and you look at what is necessary for a successful development to occur. That's the hardship. It's a bottom line hardship. Now, with respect to density, we've asked for some relief there. I think we've addressed density in terms of open space.
Sorry.
In terms of open space, we've satisfied the criteria of open space, but we have an FAR issue. Again, that is generated by just the apartment site. But if you look at FAR in conjunction either with the parking lot or the golf course, the FAR, floor area ratio, is like de minimis. It's like nothing. So we're asking for your help in looking at it from that perspective. The other thing I would like to note is that we've made a lot of representations tonight and the last time we were here. And your attorney and I had a recent conversation, and the question was, well, how will we know that you're going to do what you're going to do? And that's an appropriate question for you to ask, for the lawyers to ask. And what we said, and what I said to John was, we will put it in a development agreement or a PD agreement, it's the same thing. And we will put in writing, we'll negotiate those terms, but we'll put in writing the things that the village and this team agree to. And I see no reason why we can't make a representation verbally that won't be on paper. The other thing I would also say with respect to parking is we didn't even...
May I interrupt you for 1 second?
Of course.
You're just saying that you're willing to put into an agreement, which will be concluded in the future, between you and the village, about a number of parking spaces, and yet we are required to look at parking spaces and judge your request for your variance as per how many are being asked for, and you're telling us it's an ambiguous number which will be decided later.
And with all due respect, Mr. Chairman, that's not what I was saying. What I was
That's
saying
what I
is,
understand.
if there's representations with respect to what we will do about off-site parking, what we will do about shuttle service, what we will do about making sure that no other event goes on at the hotel other than a large swim event, those sorts of representations, and what we have said here, that's what we put in writing. We've made representations about improvements that we would offer to the resort. You've heard them about the golf carts, about the ballroom, about the security area. We've made representations. That will go in writing. The other thing is, we among the parking and traffic issue, we didn't consider valet and shuttle and Uber, which I know is kind of new to many of us, but they're the realities for us mostly under the age of 40. And then finally, I would just reiterate one thing. And we note that many of the objectors, and we respect their opinions, but they're the beneficiaries of the same thing that they're objecting to. And we said that last time, and I think it's worth repeating. They're living in an R4 zoning district, and they're objecting to basically a higher zoned residential development to their east. So with that, we are available for any questions. I hope we were clear in responding to your question, Mr. Chairman, and we thank you. I'm sorry, to their west, not to their east, to their west.
Our attorney has requested to speak.
Dan, just two comments. One, can you speak to the sign variance just to address some of the findings of fact? And also, just to clarify, although you did allude to potential parking on the hotel property but off-site of the 18 acres, just to clarify, that's not part of your presentation or part of the approval process
If we're
that
talking
you're
about the
seeking.
maintenance lot, that's correct.
Yes,
But
the
we
maintenance lot that may provide 100-some spaces in the future is not part of the parking calculations when the village determines the variance, nor is it part of the site plan that this commission is considering. That's something that you may be able to offer in the future, but again, We didn't publish for that, and it's,
That's right, and you and I talked about that.
yes.
We talked about the 4 signed agreements for offsite that we have secured and given to you, but that's correct.
Okay.
And signage, I'll leave that over to Peter.
So to my fellow board members, if I may, the 128 parking spaces that may be generated in the future are not to be considered on our decisions this evening. Please go ahead.
But the 47 are?
Yes.
Again, that is all we have, and look forward to addressing any questions you may have later in the evening. Thank you.
Thank you, sir. All right, at this time, I would go to the public comment, and I would ask probably the attorneys from the Homeowners Association. I will give everybody plenty of time to talk. I never shut anybody down. But I'm realizing how many people have probably got to want to say something if the subject has already been covered that you wish to talk about. Please just come up and say, I agree with the project or I disagree with the project. But we don't have to hear the same thing over and over because we're going to be here for quite a while.
Mr. Chairman, Kevin Gallagher and I and our witnesses will speak on behalf of the homeowners.
Please, if you would speak at the podium, otherwise the home audience cannot hear you.
What I wanted to
And the people
indicate
in the
is
other room.
that in order to save time, Kevin Gallagher and I will speak on behalf of the homeowners in the association. We will take their place. Let me first state that we've got 2 staff reports and only 2 staff reports. The first one indicates a deficiency of 923 parking spaces. The second one indicates a deficiency of 523 parking spaces. Sometime between the first report and the second report, your code was reinterpreted to eliminate the need for 400 parking spaces. The question before the board is whether or not you can vary the code. What you heard from Mr. Faywell, that they're trying to get to what is the right number for the site. That's not a variance. They're negotiating what the parking requirements should be for the site, should be for the hotel, should be for the natatorium, and should be for all of the uses that they're trying to combine on that site. That's not a variance. They're trying to negotiate what your code should require. Now, by way of introduction, I am Scott Day, and this is Christina Morrison, my law partner. We are from Day, Robert, and Morrison, 300 East 5th Avenue, Suite 365 in Naperville, Illinois. Along with attorney Kevin Gallagher, who is here, we represent the Oak Brook Hills Condominium Association. When we were last here, we requested 30 days so that we could go through the more than 3,000 documents that your staff was good enough to provide us, and we did indeed do that. We were directed to meet with the developer, and they left out one component of what we had suggested to them. Item number 1, the natatorium as a use on this 144-acre site moved to the west of the site and with adequate parking per the code will be acceptable to the homeowners. If you have to have an apartment building, you can probably negotiate a compromise settlement agreement that would put a 2.7-acre apartment building at the southwest corner of the site. Those are the provisions that we presented to them. That's the corner that's adjacent to the R6 senior housing facility and across the street from the townhome facilities, both of which are zoned in the R4 category. The property would have to have its access onto Cass Avenue so that all of the traffic would dump directly out onto Cass Avenue, would not infect the interior roadway network, and would not impact the parking lot of the hotel. At the prior public hearing, I went through the documentation that Jill provided. I found 3 very interesting quotations. Slide number 2. This is a quotation that we found that reads as follows. This is not a situation where the developer can get the parking wrong. There is nowhere nearby for excess parking demand to go, no on-street, no overflow lots, etc.
If I may interrupt, please, I have a request. Is there a Teresa McMurray here? If so, please see Police Chief Mulhern outside concerning your car. Teresa McMurray, if you're here, please see the police chief. I'm sorry, sir, please.
This is the quotation we found in the 3,000 documents that were provided by your staff, and it's interesting who this quotation came from. It's from the village engineer. The village engineer reviewed this site plan. He wrote a report to the village staff and specified this is not a site where you can get the traffic wrong. So there was a question as to, where these documents came from, whether at the last minute. These are documents that are in your file. The next quotation. Generally speaking, February is not a good month for traffic counts, particularly in the vicinity of the golf resort. KLOA should adjust their capacity analysis for this. Once again, this quotation is from the village engineer back in March. So the KLOA reports and the study regarding the traffic generation and the parking demand, they were done in February. Not a lot of golfers in February, not a lot of use of the hotel in February. Next, this is an interesting quote. The developer should provide plat of vacation for easements to be vacated. That came from the village engineer 3 months ago. And I'll come back to that issue at the end. Let me start with a historical overview, because until you understand the governing documents that regulate this property, you don't really have a clue as to what you're dealing with in this series of zoning requests. Slide number 5. The property was originally annexed back in 1971. We've included a copy of this annexation plat in your binder. Next. Up until 1984, the property was situated as farmland and zoned in the R1 category in Westmont. That's tab 2 in your binder, and that's a 1980 photograph. I believe it's a Sidwell source. In 1984, the Butler heirs, Jory, Michael, and Frank, came to the village along with a battery of attorneys and requested a development plan for this particular site. Ultimately, after months of dealing with the property, and Harlan Spiroff was your attorney, working to write with the attorney for the other side the zoning ordinance for this property, it became the B3 parcel. Ordinance number 84131, slide 7. This is in your exhibit packet as tab 3. This was the one that created the B3 zoning. It's virtually the same text that you have today. The next one is Ordinance 84132, adopted the same day, rezoned the Butler property to B3. The next one, slide 9, is Resolution 84133. Because B3 has a specifically defined process, you first go through a process where you define a preliminary plan, and ultimately you decide what is called a final plan. Once you have a final plan, there are different regulations. The preliminary concept plan for all 144 acres was approved the same day. And then ordinance number 84134 was adopted the same day. That was a final concept plan for the golf course and for the hotel. So with the exception of the 16.9 acre parcel of property, this site has a final concept plan, and all of the regulations related to a final concept plan apply. In 1985, the private property owners who owned these 3 chunks of property, what became the office site, the golf course site, and the hotel site, recorded a document under R85-90357, got the cover page there, slide 11, and that's tab 4 in your binder. Very big, very beefy document. These are private land use covenants, rules, and regulations that impact the use of the golf course, the hotel, and the 16.9 acre parcels that my clients now live on. 1987, the golf course opened. In 1988, Oak Brook Hills assessment plat was adopted and formalized the 3 parcels that you see. There was never a subdivision here. This was never subdivided. You have an assessment plat with a 16.9 acre parcel, which is the residence, the 19 acre parcel, which is the hotel site, and everything else that's the golf course. 3 parcels in the assessment plat. In 1992, Michael Butler had taken ownership in the office parcel of property, which is now the residences. He suffered financial reverses, and Michael Butler lost the property to a lender. The lender sold the property to the Gray Development Group, and the Gray Development Group came before this panel and asked for rezoning to R4, which you gave them. And then you went to the village board and asked for permission to develop the site. Slide 13. There were objections that were issued, and the objections came from the hotel owner. The hotel owner came to the village and said, you can't authorize a residential development on the office parcel. You can't do it. Your B3 zoning requires the consent for a change of the final plan, and that consent is required from both the village board as well as every person with an interest in the property. That objection was ignored. Ultimately, Ordinance 92-9 was approved in 1992. That's slide number 15. It's tab number 7 in your binder book. Lastly, there was a resolution R92-15, which was the final site plan approval, and that was for 84 homes. That's slide 16, tab 8 in your book. Immediately, there was a lawsuit. Everybody sued everybody else. The hotel owner tried to stop the residential development. The residential development and the village wanted to impose the R4 zoning. There were lawsuits back and forth over the restrictions and the covenants and easements. We've given you a copy of the appellate court decision, slide 17. And all of this history is documented in the lawsuit between the village and the developers and the owner of the hotel and the owner of the residential development property. And the court ruled, number one, the R4 rezoning by the village was unconstitutional. It said you can't stick an R4 development in the middle of a B3 development. It's completely inconsistent with the entire purpose of the B3 zoning district. You can't do it. The court undid the R4 zoning. The B3 veto provision. There was a provision in your ordinance that said that the owner of the hotel could not, the village could not rezone the 16.9 acre parcel of property unless the owner of the hotel consented. The court ruled that was unconstitutional. So the rezoning to R4 was unconstitutional, and the original zoning for the district was unconstitutional because it was a delegation of the village's authority. But there's one that the village won, and that's on the easement agreement. The easement agreement was challenged, and the assertion was that you couldn't use the 16.9 acres for residential because the easements that benefited that parcel did not apply to residential use. The trial court said, no, that easement agreement is clear. It applies to residential use. And number two, it's enforceable, and I'm not going to change it. It's a clear agreement. Those are the three rulings that came out of that decision. I've provided the entire decision. In 2002, Ordinance 0219, conditional zoning again for the 16.9 acre parcel. And you heard Mr. Shapiro say, oh my goodness, they rezoned this to R4, the cat's out of the bag. You have to read what the village found with respect to the 16.9 acre parcel. And I've quoted the whereas provision. Whereas the Westmont Planning and Zoning Commission, this body, specifically made the following findings. One, that the conditions changed upon the property since it was zoned as B3 due to the presence of wetlands. That due to the presence of significant wetlands on the subject property, a substantial development under the B3 zoning is no longer feasible. That since the rezoning of the subject property to B3, it has remained vacant and undeveloped, showing a lack of market for development consistent with B3 zoning. And that based upon the evidence presented at the public hearing, the proposal represented the highest and best use. That ultimately went to a final plan. Ordinance 03121 was the final plan approved in 2003. It was 46 units. So the R4 that you're talking about, you know, their argument is R4 is R4. This is 2.7 units per acre. The proposal that they're asking to put next door is 114 dwelling units per acre. There's no inconsistency there, they suggest. Now, which of you that lives in a neighborhood, 2.7 is a single-family residential density. Who in a neighborhood of single-family residential lives immediately next door a development where this village has zoned it for 114 units per acre? I think we could survey this room and nobody. Ordinance number 03122 was a planned development contract. This was negotiated by the village, slide number 22, and tab number 13. Under this ordinance, you actually imposed the legal description that involved the redevelopment. Parcel 2 of the legal description that's involved in the contract between the developer of my client's property and the village specifies a perpetual non-exclusive easement for ingress and egress for the benefit of Parcel 1. There was an express recognition in your contract when my client's property developed as to certain easements that benefit that parcel of property. It's stated right in the contract that we've provided you a copy of. So as of 2003, 13 years ago, you had a final plan for the hotel, You had a final plan for the golf course. You had a final plan for the 16.9 acres. You had an enforceable covenants and easements agreement, and you had B3 zoning that was held by a court of law to preclude residential development. That's what you had. Then, in 2014, here we are 11 years later. The petitioner signed a contract to purchase the property, slide 24. And of course, when you close on property, you have to file an affidavit stating what you actually paid for the property. It's required, and it's under penalty of criminal prosecution if you falsify. The purchase price for the entire transaction was $25,100,000. But personal property was $6,275,000 according to the revenue declaration. So the actual acquisition of the golf course, leasehold, and the hotel was $18,825,000. Slide 24 is the revenue declaration. And at the time, they recorded a warranty deed. The warranty deed is the conveyance to the petitioners in this case. We've given you a copy of the warranty deed at tab 15. Slide 26. Here is the legal description for the exceptions. These are property rights that the petitioner did not acquire when he bought the land. It's subject to covenants, conditions, and restrictions in temporary construction and landscape easement contained in the agreement dated October 17, 1985, and recorded October 18, 1985 as document number 8590357. That's the document that he took subject to. And if you'll recall, this particular document was incorporated as tab 4 in the documents that we've already provided you. So before the purchase by Peter Duman, we were told that he met with the village. He came over and met with the village to make sure he could do what he wanted to with the property before he closed on it. So before he closed on it, he knew he was dealing with B3 zoning. He knew that the B3 zoning didn't permit residential use. He knew exactly what the parking codes of the village required, and he knew what the comprehensive plan said. So he knew that what he's asking to do tonight, he couldn't do. So before I turn this over to the consultant, I think the question that you started with of the petitioner, how is it a hardship to comply with rules and regulations that you yourself asked for? When you ask for R4 zoning on the parcel of property and then turn around and claim, I can't possibly comply with the parking requirements for R4. My goodness, that's really punitive. And if I put in a natatorium and all these things that I really want to do, you know, I can't be asked to comply with the code. That's not a hardship. We have several consultants who would speak, and when I return, I'm going to address why that history precludes legal approval of this particular application. First, we have Kevin Gallagher will introduce Joe once again. He's our traffic consultant, and they will address traffic and parking. But I must say, we are limited to the information we had when we prepared this. And of course, we just received the recent information as of last night. We can't address that.
Thank you very much, Mr. Chairman. For the record, my name is Kevin Gallagher. I'm an attorney in Naperville, Illinois, and I've been practicing for about 27 years. I have Joe Regis with me. He's from Robert Hamilton Partners. He's made a presentation and prepared a report that he submitted to you for your review at the last meeting. He's had an opportunity to review additional documents that have been submitted and that have been FOIA'd from the Village of Westmont. And I'm going to ask him some questions about what his findings are based on the additional documentation that he's reviewed. So, Mr. Regis, you're familiar with the proposal, and can you tell me what documents you've reviewed and becoming familiar with the proposal?
I have reviewed the Westmont staff report presented ahead of the last Plan Commission meeting and a revised Village of Westmont staff report that was, I believe, issued last Friday for this meeting. There has been some information provided for the natatorium that is fairly specific as to the number of swimmers and parents using the natatorium during some of the swim meets. In the latest staff report from the Village of Westmont, there was a change from what I had initially from the last meeting in the number of studio, one-bedroom, and two-bedroom apartments that I picked up on with the revised report of findings. I also picked up on the information presented on the swim meets proposed or that could use a proposed auditorium.
Have you reviewed the current conditions at the site?
Yes.
And based on the current conditions, have you reached a conclusion as to whether or not the parking there is adequate?
As I stated at the last meeting, and I'll state again at this meeting, I have found that the current parking is insufficient for the current uses as the site exists today.
And how did you come to that conclusion?
Utilizing Westmont Village Code for calculation that's applicable for the hotel. That's straightforward. There's also in the Westmont Village Code a calculation for, call it convention space, which they have. There's not something in Westmont Village Code for the golf course. I utilize what I feel to be the next best, and a lot of folks feel to be the next best source of data, which is ITEs, or Institute of Transportation Engineers, Parking Generation 4th Edition, which uses roughly 7.5 or 8 spaces per hole. So using the calculation from Westmont Village Code on the hotel, Westmont Village Code for the existing conference space or convention space, and ITE 4th, because it's not in your code for the golf course, I total up to over 1,000 spaces required just for the existing uses.
And how many spaces are currently located at the site?
Currently located at the site, there are 900 and I do not want to come up with the wrong figure. I wish I could remember these, but there's been a lot of numbers floating around. There are 979 spaces compared to the 1,021 I calculated for the existing uses, showing a deficiency for what exists today of 42 spaces.
Okay. If the development was to proceed with only the apartment building, would there be sufficient parking at the site?
No.
And how did you make that determination?
Using, again, the best source of information available, the Westmont Village Code. And there's been talk about, there's been recent revisions to it, and I used those recent revisions. The parking requirement for the apartments alone is 505, and that reflects the changes in the number of studio, one-bedroom, and two-bedroom from the most recent, or say Friday, Westmont staff report. And there's a requirement of, I used a lesser requirement than the village did for the retail in the apartments of 20. So it's a requirement of 525 spaces for the apartment building itself. And from where I stand, if the existing uses and parking is deficient, and you add the requirement of 525 spaces, at least at the last meeting, the proposal was to provide 1,257 total, and I testified at the last meeting specifically to this situation, because to me it was critical to look at, without the natatorium, but with the apartments and the existing uses. At that time, I reported a certain number based on the revised numbers for the apartment building for the studio, one and two bedroom. The deficiency is 529 spaces. That's with the golf course open, the hotel completely occupied, the convention center in use, apartments built. Why I thought that was important is looking at a weekday use where if there's a corporate event, and there are pictures provided in the report from the last one I presented, it's also in this report as well. In April, there were somewhere between 500 and 550 cars in the parking lot, and that was one slice that we were able to get during the week of a corporate event. My biggest concern with this analysis is if there is some type of event during the week and there is a deficiency of 500 spaces, we're not talking a small deficiency, and as your own consultant pointed out, there's no place else for where these people can go. It's not like there's adjacent parking. You can't park on Cass. There is parking available in Oak Brook Hills for their own use, but 500 cars during the week, that's the people living in the apartments cannot park. Where do they go? And so on. That's why that analysis, to me, is critical. I believe your consultant picked up on that as well.
Now, there's been a lot of discussion about how to calculate what the proper parking totals are for an auditorium. And I take it from the discussions that there is no data in the ITE that would say this is the number of parking spaces that are appropriate for an auditorium. So how did you calculate what you believe is the proper amount of parking for the natatorium? Did you look at other natatoriums in other areas? Or?
Currently, yes.
Okay.
Originally, I used the closest use, Westmont Village Code for parking, which is, call it a stadium or a conference center. It's the same 1 to 5 you use for the conference center inside the hotel. There's been some question whether there's 1,200 seats or 1,400 seats, but I used 1,400 divided by 5, which was 280 seats, the last Planning Commission meeting. Since that time, information has been submitted, I believe by Mary Ann Kaufman, on some of the possible meets, which has more detailed information on the users, and the number of swimmers, the number of parents. It does not discuss the number of meet officials. Reading through, there's going to be a lot of coaches that come to this event, and so on. There's also been a survey of the facility at University of Indiana in Indianapolis, and also a survey of the Recplex in Pleasant Prairie, Wisconsin, outside of Kenosha. I've also looked at others. I have revised the amount of parking that I say is necessary for the natatorium based on the data provided by Mary Ann Kaufman, because what I am not seeing is what you might typically expect, that if your requirement is 1 parking space for 5 seats, that everybody's showing up in a minivan or in a sedan, mom, a dad, and several kids, no coaches, no meet officials, and the 1 to 5 makes sense. But with the information provided, if during a given 4-hour session at one of these swim meets, there are 400 students, there's 400 parents. So that's 2 people per car, which is a lot less than 5 people per car. So the data provided seems to indicate that at least what I did the first time, which was applying the stadium, you do have a pool of 1 space per 3 people using the facility that your staff originally used, backed away from, and my numbers have gone back to that, or have gone to that, just because if you have 1 parent with 1 swimmer, you're looking at 400 people, or 400 participants with 400 parents arriving in one car. I backed off of that number a little bit because there's the assertion that some of the folks will be staying in the hotel. That's fine. If there are 6 to 9 sessions during one of these swim meets, you can assume out of the 800 people, the 400 swimmers, the 400 parents, that a sixth or a ninth of those people will be staying inside the hotel. If you add in coaches and meet officials, again, no numbers, I've arrived at a number for the natatorium, and it would be beneficial to get additional information to determine exactly what the parking impact is on some of these other surrounding facilities. Is there data available for the number of swimmers, parents, coaches, meet officials, employees of the natatorium? What exactly are we looking at? Is the 1 to 5 the most appropriate? I don't think so. My latest analysis, based on the information provided, is a need of approximately 550 spaces, not 280, based on the best information available.
And that's just for the natatorium?
That's just for the natatorium.
So when you take the deficiency, or the number of parking spaces that are needed for the natatorium, plus the deficiency that currently exists, plus the deficiency that will be created by the construction of the apartment building, how many parking spaces short is this development?
839, which is fairly close, but a bit less than what staff had originally.
Is that a significant number?
Yes.
Do you think that the petition that's been submitted accurately reflects the parking needs based on your analysis?
No.
And is off-site parking permitted under the Westmont zoning code?
Off-site parking is permitted under very specific conditions.
Have they been satisfied here?
No.
And then finally, in your opinion, well, let me back up for a second. The petitioner is saying that there's a hardship that's been created because, and so he needs a variance from the parking. Who created the hardship in this case?
The applicant.
Thank you very much.
We will next have appraisal testimony from MAI appraiser Michael Maroos. I will let him introduce himself and also give his report.
Good evening. My name is Michael Maroos. I'm president of Maroos & Company, located at 300 South Prospect, 300 South Northwest Highway, Suite 204 in Park Ridge, Illinois. I apologize for you receiving my report tonight, but I was reacting to information after the last hearing, and this report was done on an expedited basis and couldn't have been done any quicker. So I have been a real estate appraiser for 40 years. I've held the MAI designation for 35 years. I've done several $1 billion of real estate appraisal work in DuPage County, have been hired by the county, by the County Forest Preserve, by public bodies proximate, including Oak Brook, Hinsdale, Clarendon Hills, Willowbrook, in relation to land use and valuation issues. My office and myself have probably done over 100 value impact studies, including the impact of lights, waste transfer station, athletic fields, religious uses, proposed commercial uses throughout the Chicago metropolitan area. In this instance, I was asked to review the proposed plan and all the various studies and look at the impact of that plan, particularly on the residence is of Oak Brook Hills, which is a 46-unit luxury residential development immediately adjacent and obviously sharing access and other items with the development. I'm not going to bore you with my 25-page report. You have it here, so I'm just going to summarize it fairly efficiently. So we looked at all the studies. We looked at market conditions. We took into consideration the significant amount of work that we've done in the area. Probably have appraised over 50 hotels in the last 5 years, so similar with those uses, very familiar with commercial uses, very familiar with transit-oriented development uses. I was a former public official in Park Ridge, and under my term, we did a $125 million uptown redevelopment that was a transit-oriented development, mix of commercial and residential. So I've kind of sat on both sides of that table. In this instance, it was interesting looking at the studies, and obviously you've heard the traffic analysis, which seems to be going back and forth a little bit here. I also, when looking at value impact, look for acoustic or noise studies. I didn't see any. Look at photometric studies. I didn't see any. Also was concerned because the natatorium is only maybe 150 feet or so from the nearest residences. And my experience with having 2 kids that swam at a high school level, that, you know, there's chlorine, there's exhaust system, there's noise, there are HVAC units, you know, which is similar to any big box proximate to residential uses. I didn't see any of those studies in my analysis. I'm going to give you my conclusions based on my experience in looking at the proposal, and then I'm going to explain where we did 4 match pair developments in DuPage County to look at similar situations. There's nothing similar or identical to this use. So we looked at road noise, we looked at proximity of detrimental uses, we looked at proximity to a tennis club in Hinsdale, and generally the most proximate residences were negatively impacted by these uses. I also took into consideration, obviously, the traffic patterns, which are obviously in conflict with my clients accessing their residence. I also took into consideration basically a big box being built within 150 feet of some of their residences. I also took into consideration that the average price, probably on the low end of these 46 units, is $850,000, which constitutes a value of almost $40 million, which is more than double the real estate price that was paid by the developer. So they have a significant economic stake in this. So I took into consideration, again, all the various users that would be coming and servicing both the natatorium and also the proposed apartment development. I looked at the size. I looked at the intense use, besides the traffic, introduced into a residential area. And again, typical single-family or low-density multifamily is 2 to 6 units per acre. And I think you've heard testimony of the hotel having, not the hotel, the apartments having 114 units per acre. Our experience with probably appraising 50 suburban apartment projects that were not in a CBD generally are 15 to 25 units per acre. That's the density, not 114. 114 is downtown Evanston. And we looked at, obviously, economic conditions, which were somewhat confused, which we see this all over, because the market got hit between 2008 and 2013. And those issues were taken into consideration. And generally, multifamily was impacted harder than anything else. Also took into consideration that high-value residential is generally impacted at a greater economic level by the introduction of what we call detrimental conditions or negative uses. So quickly going through the report, again, I looked at the area which you've heard about, and I think you probably know better than I do. I'm familiar with the area. I played the course. I've been on the property numerous times. And again, we've heard about my client's luxury development that's been successful. I think everybody knows about the proposed development, so I don't have to get into that. In my report, we look at market conditions and building permits, price points, information out of the MLS going back to 2005. But essentially what was done was called a matched pair analysis as part as to looking whether development of the proposed apartment and natatorium would have any impact. Maybe it wouldn't. Until we looked at the numbers and we looked at the impacts, we really didn't know. So we looked at the Oak Ridge Creek subdivision in South Burr Ridge. We looked at the Manors of Hinsdale condominium development in Hinsdale, the Briarwood Lake subdivision in Oak Brook, as well as the neighborhood immediately west of Interstate 294 in Hinsdale. The goal here is to look at similar properties. One is called a control that has similar size, similar age, similar demand that's not impacted, and then the target is the one that's impacted, the one that's closest to the use. So the Oak Ridge subdivision is located on the east side of Madison Street, about at 94th Street and Burr Ridge. It's a high quality, basically 1 acre lot size. The house sizes are about 3,900 to 4,500 square feet. The far south end of the development has 3 different things going on. It's got an electrical transmission line. There's actually 2 sets of poles in the electrical corridor. There's 2 freight track lines, and there's also the Knollwood wastewater facility. The bottom line there is we looked at one house that's most proximate and similar houses currently on the market, and also houses when this last sold, and they're indicated just on a simple match pair of significant difference in value, on average about 30% lower than the houses that were further north away from the detrimental conditions. And I'm not saying these uses are similar to the subject, they're just detrimental conditions, and they clearly impacted the value of this property. The Manors of Hinsdale is a 56-unit condominium development, kind of the low end of Hinsdale, so it's really not comparable price point to the subject. It's just south of Hinsdale Central, but the east end of the development is immediately west of the Hinsdale Racquet Club. So you have 2 metal buildings that have a peak of about 35 feet high that basically get quite close and very visible to the east end of the townhouse project. We looked at sales, 5 sales, and looked at them compared to the property that was most proximate to the club. And the unit price of the house closest to the club was significantly lower than the prices as you went farther to the west towards Madison Street, and we're not looking visually at the tennis club. The reality is the tennis club was there before these were developed. So these townhouses were built after. And then we looked at Briar Lakes subdivision, which is at the northwest quadrant of 31st Street and 83, another gated community, probably 30-plus years old, very nicely done. And in this situation, we tried to isolate a house that was most proximate to 83. They do a nice job buffering, but ones that were not on one of the lakes. And we looked at 5 different sales. And again, clearly, the transactions that were further in the development, farther away from 83, reflected higher prices. And I believe that number was about 32% on average. The last had to do with an attractive modern house in Hinsdale that backs up to 294. This is at about 3rd Street. This house was at 517 Columbia. The backyard is buffered. It's at a point at 294 where there's a sound wall. We looked at other sales still in Cook County, so we tried to not mix up DuPage and Cook, so we went further to the west, stopping at County Line Road, and looked at similar lot areas, price point, or year built. This was built in '96, so the comps were built between 1986 and 2002. And again, there was a clear differential. And, you know, in the summary, on average, I'll go back, the first one, the Oak Ridge Creek, the average diminution was approximately 30%. This is on page 16 of my report. The Manors of Hinsdale Commons, 11.4%. Briarwood Lakes, 32%. Hinsdale west of 294, 41.9. What did we glean from this? Well, clearly, the proposed development is not as bad as being by electrical transmission corridor, in my opinion. Clearly, it's not as bad as being proximate to 294. Being next to the tennis club is a real interesting comparable. However, we're talking about condos in the $200,000 to $250,000 range, as opposed to detached and attached residences in the $800,000 to $1.1 million range. After this, and the conclusions really took into account basically the proposed big box next to us, the introduction of high-density apartments, the traffic, the parking, the view, and just the change of character in the neighborhood. And what's also obvious is in my opinion, is the houses immediately adjoining the proposed development are going to be impacted worse because, number one, they're going to see it, and number two, they're more proximate to the traffic issues. The houses farther in my opinion, will not be as impacted. They're farther away, they're closest, they're on the golf course, they have the premium views, and they're going to have less traffic. However, another interesting fact in real estate, when you bring the average down or you bring the low end down, it affects everybody. So if we have a range now of 850 to, let's say, $1.1 million, and that number goes from 650 to 950, it's also going to bring those higher price numbers down. So in conclusion, and there's a lot more detail in my report, it was my opinion that the residences, and there aren't many, but they're right proximate to the proposed development, would have a diminution of 15% to 20%. The residences farther in would have a range of diminution from 7% to 15%. Even at an average of 10% of 39 million, your overall number becomes 3.9 million. We can do the math. If we go a little higher, it's obviously going to raise that number. Thank you.
I would like to reintroduce Ken Rathje. He is the planner. He's got some testimony regarding the zoning issues.
Chairman, members of the Planning and Zoning Commission, good evening. I qualified myself last night, just briefly. I spent 29 years as Community Development Director for the Village of Downers Grove and have operated my own consulting business for the last 13 years. I have dealt with literally thousands of petitions and carried Downers Grove through some of the largest growth spurts that it had during the 70s, 80s, 90s, and early 2000s. Last month, I pointed out that the provisions of Section 902A limited where waivers could be granted only to the provisions that existed within the zoning district of the underlying zoning. It appears my warning took root because the petitioners or the village, whoever's responsible for publishing the public hearing notice, republished the public hearing notice on June 1. One of the items, item D, says zoning code variance requested to reduce the total required number of parking spaces for an 18-acre land area. We've heard a lot of testimony about the fact that there's some question as to what the deficiency of the parking is, but it seems to be a significant deficiency. One of the things that was one of the simplest things and the earliest things I learned was if a development has inadequate parking, it's doomed to fail no matter how good it is. People can't get there easily, can't find a parking space easily, they don't come. We know that there's a variation that has been filed for the number of parking spaces, but there's a couple of other things, parking related, where variations have not been requested. And due to the relatively narrow nature of how the public hearing notice was published for only to the number, I thought you'd be interested to hear what they are. In your documentation, you have been given, I believe, 3 letters from property owners of 4 properties, 1 in the village of Westmont and 3 in the village of Oak Brook for off-site parking. It's a good beginning. The terms of your code are very specific in terms of off-site parking, especially under Section 1005. But you have to also look at Section 1006L, which says, provided such facilities are within 600 feet walking distance of such building. And then that cross-references back 1005. Took a look, and I used Google Earth, and I didn't use anything terribly sophisticated. And if somebody wants to debate, a couple feet here or there, I'm willing to be corrected. But I located where these parking spaces are. There are the 100 parking spaces for 625 Enterprise Drive, 3.48 miles away. That's 18,400 feet. 80 parking spaces at 709 Enterprise Drive, 3.42 miles, 18,050 feet. 616 Enterprise Drive, Oak Brook, 3.55 miles, 18,730 feet. And 600 Oakmont Drive in Westmont, 1.48 acres, or 7,820 feet. There's been no request made that I am aware of asking this board to vary the requirements of the relative location for off-street parking. Further, all of these parking lots have principal buildings which they serve. If you go to your section 1006D, I'll read the whole section because some of you don't have ordinances. The beginning section says off-street parking facilities for separate uses may be provided collectively if the total number of spaces so provided is not less than the sum of the separate requirements for each such use, and provided all regulations governing location of accessory parking spaces in relation to the use served are adhered to. Here's the interesting sentence. Further, no parking space or portion thereof shall serve as a required space for more than one use unless otherwise authorized by the Planning and Zoning Commission. I don't know if it's normal and customary that the Planning Commission would have to rule that as a variation, or that would be done ministerially but nonetheless, you'd have to have testimony and make findings that these off-site parking spaces are free and clear to be used to meet and satisfy some of the requirements for the uses that are before you this evening. That has not taken place. I like zoning ordinances, so I went to the Village of Oak Brook's zoning ordinance, specifically Section 12-13-3J. They have a provision called collective provisions. And the first part, which I'll read for completeness, is there, but the second part's the interesting part. Off-street parking facilities for separate uses located in a principal building on a single lot may be provided collectively if the total number of spaces so provided is not less than the sum of the separate requirements for each such use, and provided that all regulations governing location of accessory parking spaces in relationship to the use served are adhered to. Very similar to the Village of Westmont's. Then in the second sentence reads, in addition, any parcel of land that has excess parking beyond what is required by this chapter may allocate excess parking capacity to any parcel or use that is directly contiguous to it under a shared parking arrangement if it meets the applicable requirements of this chapter. Such arrangement must be in written form with notification provided to the village. So they allowed shared parking if there's an excess, but only to the neighbors. Their off-site parking requirements are virtually identical. It appears that one community may have borrowed from the other community. The only difference is that Oak Brook requires that the maximum distance for an off-site parking space is 550 feet rather than Westmont's 600 feet. So even though there's a indication that we have property owners who may be willing to allow people to park on their property to satisfy some of the parking requirements for Oak Brook Hills, it doesn't meet the requirements either for the Village of Westmont nor for the Village of Oak Brook, which has the majority of the spaces. With respect to parking stall sizes, we received a new site plan just yesterday, and I kept looking at the parking spaces, and there was a number of 16-foot deep spaces and a number of 18-foot deep spaces, and I just couldn't figure out how that could be because I'd found the standards, parking standards in your standards of design. And it says the standard dimension for any automobile parking space shall be 10 feet wide by 20 feet long. Then there's language about minimum width of 16 feet for handicapped. Then it goes on to say the actual paved length of a space may be reduced by 2 feet where adequate head-in bumper overhang space exists, exclusive of required screening and setback requirements. I get the 18 feet if there's a bumper overhang. But then I found some 16-foot spaces. And it seems as if the ordinance has been interpreted by taking this section 401(2)B, which says where parking of long-term duration, in parentheses, 4 hours or more, is expected, the standard dimension for a parking space may be 1 foot, may be reduced by 1 foot width and 2 feet of length. Well, it says from the standard is 10 by 20. The standard is not by default 9 by 18 and then 2 more feet. There's no variation requested for parking stalls of 16 feet. I was very curious of what the parking stall sizes was in the parking structure. I looked at many of the 3,000 pages that came to us. I saw what I would consider to be a sales quality drawing that shows the apartments wrapped around the parking spaces, but there's no dimensions, called Ms. Ziegler this morning and ask if you have a drawing that discloses what the intended parking stall sizes is in the parking structure. And she said, no, they have not submitted one. So we don't even know if there's going to be substandard sized parking spaces that, in addition to the 16-foot deep ones, that will need to have a variation. Now, Mr. Chairman, you requested how the standards were going to be met for a variation. And first of all, out of curiosity, did the petitioner file a variation petition and file the fees for the parking variation? Okay. Just was wondering about that one. I think Mr. Shapiro was very clear in his letter of June 8th. It's on bottom of page 4, with his feelings towards your variations. Section reads, lastly, please note that even though the initial notice for the public hearing adequately advised the community of the zoning relief we are requesting, we have renoticed the June 15, 2016 meeting to address some concern that the parking waiver in the plan development should be identified as a variance. While we believe the issue of parking was appropriately advertised, we have renoticed the meeting to be conservative and to avoid any unnecessary issues in the future. As we mentioned at the last hearing, our responses to the waiver request relative to parking have been drafted in a manner consistent with responses to a requested variance. Therefore, we wish to adopt those responses as the responses for the parking variation. By doing so, we are not necessarily agreeing that we need the parking to the extent staff has indicated. Rather, and as stated above, we believe we only need a variance of 54 spaces. Well, I had to do some looking to find what the original statement was to justify the waivers. And I found something that came out of our FOIA folder number 2016-03-04 PZC. And the petitioners provided a series of findings for the special use. Take a look at the provisions of your zoning ordinance, and the standards for a special use are significantly different than they are for a variation. Standards for a variation appear in section 13.07. And under standards for a variation, it starts off with 1, the Planning and Zoning Commission shall not recommend a variation to the regulations of this comprehensive amendment as authorized herein unless it shall have made findings of fact based upon the evidence presented to it in each specific cases. Normally, a zoning ordinance says if a petitioner comes in and meets the standards of the ordinance, you have to give them a permit. This one says you can't do it unless you make the findings. And the findings are as follows. The property in question cannot yield a reasonable return if permitted to be used only under the conditions allowed by the regulations in the district in which it's located. The parking spaces that now occupy the site need to be vacated from the sites where they want to build buildings because they need to have building pads established and made available so they can occupy those former parking spaces with an apartment building and with an natatorium. The plight of the owner is due to unique circumstances. Unique is a word that means very rare. I don't know what those are, but it certainly appears that trying to make the parking go away so they have room to build buildings. C, the variation, if granted, will not alter the essential character of the locality. I think we heard from Mr. Regis some of the implications of having inadequate parking. But the ordinance goes on. Those aren't the only 3 standards. Under paragraph 2, for the purposes of implementing the above rules, the Planning and Zoning Commission shall also, in making its recommendation whether there are practical difficulties or particular hardships, take in consideration the extent to which the following facts favorable to the applicant have been established by the evidence. I heard Mr. Chairman ask several times for evidence and I didn't hear much. But the standards are thus: the particular physical surroundings, shape, or topographical features of the specific property involved would result in a particular hardship upon the owner, as distinguished from a mere inconvenience if the strict letter of the regulations were carried out. Pretty flat piece of property. It has some rollingness, but it's the Midwest. B, the conditions upon which the petition for variation is based would not be applicable generally to other properties within the same zoning classification. There's only one other piece of property within this classification, and that would be the golf course. And if you give it to this developer, I'm sure that somebody that might want to redevelop the golf course would look for the same thing. The purpose of the variation is not based exclusively upon a desire to make more money out of the property. I think that one's pretty well established, that they need more money, they want more money, and that's the way it looks. D, the alleged difficulty or hardship has not been created by the owner of the property. When you buy a piece of property like this, you do due diligence. You learn what the rules are, you learn what the pro forma of the building is, you learn what the taxes are, you read the zoning ordinance, you take a look at the underlying covenants, rules, regulations, and if there's history other than that, you'll do that homework. That could have all been done. One of the things I always tell my clients when they get interested in a piece of property is sometimes the easiest thing is to walk away if it's not a good deal. I had to do that with one of my clients last week. Wasn't pleasant, but they have to do it sometimes. E, the granting of variation will not be detrimental to the public welfare or injurious to other property or improvements in the neighborhood in which the property is located. I think Mr. Regis touched on what the implications were if there's inadequate parking. Finally, F, the proposed variation will not impair an adequate supply of light and air to adjacent property or substantially increase the congestion in the public streets or increase the danger of fire or endanger the public safety or substantially diminish or impair the property values within the neighborhood. We just heard testimony about property values and where there's only one way in and out if those driveways are clogged with with cars that are not parked in an orderly manner. I think we have a question of impact on the public safety. Last month, petitioners noted that they should have less number of parking spaces for the apartments because this is a transit-oriented development. Took a look at the literature, and one of the things that I found was that typically a transit-oriented development is located between 1/4 and 1/2 mile from a transit stop. And the experts seem to think that from the successful ones that exist around the world, 1/2 mile is the de facto standard for rail catchment areas for a transit-oriented development, is because that's the distance somebody can walk within about 10 minutes. Using my Google Earth, I measured from the front driveway at Cass Avenue, not from the site of where the apartments would be, but from the front driveway to the train station, and it was almost exactly 2 miles. It's a long way to walk. I think another typical aspect of a good, successful transit-oriented development is to have a mixed use. Yeah, there are some mixed uses, and there's even some convenience stores. But in order to do your grocery shopping, to go out to restaurants, to do the things like going to the doctor, you need to have a car. Grocery store, the Jewel, 1.12 miles. Standard Market, 1.66 miles. It's a long way to walk, and I don't see people being able to successfully get cold foods home in the summertime and not freeze to death in the wintertime to walk those distances. Not only is this not a transportation-oriented development, but during last month's hearing, the petitioner talked about having to have 3 buses to transport residents to and from the Cass Avenue train station because it's too far to walk. Finally, I took a look at the Pace Route 715, which stops near there. And it appears that, for the north route and the south route, it's come about every hour. To Casson-Ogden is the closest one for the time. For the northbound, 6:58 a.m., 8:14 a.m., 9:26 a.m., 10:15 a.m. For the southbound at Casson-Ogden, 7:12 a.m., 8:29, 9:26, 10:34. You have to be very specific to get a bus to take you to the train station if you're going to work in Chicago. There's very few. So I think the notion that this is a transit oriented development is not really a well-founded. It certainly could benefit by having access to the railroad station in Westmont, but it's not a transit-oriented development. Next point is the intent of the B3 Special Development District. I told you before, I like zoning ordinances. I spent a lot of time in them. And one of the things that was very, very confusing to me at first was the fact that you have a well-structured plan development ordinance, and then you have an ordinance that almost mirrors it and has a lot of the same features, which is the B3 zoning district. You have the concept, the preliminary concept plan review, the final concept plan review, and similar types of things. And I was missing something. How in the world and why is the B3 zoning district almost a mirror image to your plan development ordinance? Well, the way that my printer printed the ordinance for the B3 zoning district, especially under section 706A, intent and purpose, left one sentence on the next page. And that sentence says, for purposes of this section, the B3 development district shall not be considered a planned development. When they drafted the ordinance, they drafted it very specifically for the piece of property, the old Healy parcel. They came up with very specific rules and regulations that parallel the plan development, but did not carry forward the language about the waivers. Established the floor area ratios, it established other density requirements, and established the specific list of uses. It appears to me that the drafters of this ordinance said these are the rules and regulations, and if you need relief from those rules and regulations, then you're going to have to proceed as a variation and satisfy all the criteria that I just previously reviewed for you. Finally, I'm sure you're glad to hear me stop talking. Last month, Mr. Shapiro called me back up to cross-examine me. First thing he asked me was whether or not I agreed that the list of uses within the district, and he had a poster board and he pointed to a couple of them, would permit big box retail businesses. It made me very curious because normally, I'm not an attorney, but normally you cross-examine on things people testify. And I'd never said anything about the list of uses in B3 along that line. So I started digging into the ordinance. It made me very curious. I found in the section 706 B2, secondary uses, under subparagraph X, which reads, stores of general recognized retail nature which supply commodities on the premises, such as but not limited to groceries, drugs, clothing, flowers, and notions, but excluding adult bookstores. If I recall correctly, those were the uses that he was asking me, my opinion, whether or not that would give him the right to have big box retailers. This evening he again said that he could put worse uses on the property that would generate more traffic. If you go a little bit further in the ordinance, under section 706D, required conditions, subsection 3 says, secondary uses as permitted in section B2 shall not exceed 20% of the gross floor area of any building or structure and shall be included in the principal building it is intended to serve. It's not giving carte blanche to take some use that sells groceries, drugs, clothing, flowers, and notions, and turn it into a venture or to some other type of, oh boy, did I just date myself, I'm sorry, a Target or some other big box routine. No more than you can make the argument that a post-exchange which sell these things would allow an Army base on the property. Thank you.
I'd like to address now some of the legal constraints that we referenced earlier. Mr. DeMond has, I think, misrepresented his authority with respect to this parcel of property. He has repeatedly stated, both in this room as well as our settlement conference, as well as meetings with the neighbors, that he can do whatever he wants in the B3 district, quote, of right. That's his exact quote. He can do a Topgolf driving range, a horse stable with foul odors, a 150-foot tall office building, a Home Depot. It's simply not an accurate assertion. He cannot change the use of the hotel property at all without the approval of the village board. He requires in the B3 district the approval of the village board for any alteration of the hotel site, and he would require the approval of the village board for any alteration of the golf course site. Ordinance number 84-134 was a final concept for the golf course. That's tab 4 in the binder that we provided you, slide 27. Once an area has been included within a preliminary concept plan or final plan, and such plans have been approved by the village, no other development may take place in such area, nor may any other use thereof be made except in accordance with the village board approved amendment. And later on, no approved plan shall be terminated after development commences except with the approval of the village board and all of the parties with an interest in the land. That last language was the one that was challenged in the 1984 litigation. It'll come up again later this evening. So the conclusion is he can't do anything without the approval of the board. Next, Home Depot and big box retail. We've already heard, slide 28, from the Westmont zoning ordinance. This is supposed to be a unified development. There are permitted primary uses, and there are permitted secondary uses. The retail's secondary use. It can't be the primary use. You couldn't put a Home Depot on this parcel even if you wanted to. It's not permitted in the B3 district. It's simply prohibited. So he's been going around telling people that he can do things with a big box that would be far more obnoxious than what he's actually proposing to put next to the residences of Oak Brook Hills. Next, he could put in a malodorous use such as a stable. I think Joe was present for our settlement discussion, indicated that he could put in a stable and have foul odors seeping into the residences of Oak Brook Hills. You know, this brings up the common law of nuisance. Even before they had zoning laws, nuisance was described, slide 29. By the early 17th century, the classic case of Allred's case established that a neighboring homeowner had a right to recover for an interfering activity, in that instance a pigsty which produced unpleasant odors. This is dating back 300 years. You can't deliberately put in a foul-smelling land use next to residential owners, and you shouldn't be using it as reference to why they shouldn't resist your apartment building. It's improper. Next, this application doesn't even list the variations that are necessary. It doesn't list the variations associated with remote parking distance from the property. It doesn't list variations from the standard that they're a restrictive covenant in unilateral uses. It proposes shipping the parking deficiencies from this site into a neighboring community. They want to actually ship the off-site parking into Oak Brook in a village where the code prohibits it, as you heard from Mr. Rathje. They want to ship Westmont's parking deficiency. They want you to approve a deficiency and then ship the problem to Oak Brook for Oak Brook streets, Oak Brook residents, and Oak Brook occupants of those buildings. That's not lawful. Now, the B3 requires 40-acre minimum. Do we have a 40-acre site? No. They claim they've got an 18-acre site. But the 18-acre site has a final plan. What they're doing is they're putting an apartment site on 2.7 acres and a natatorium site on 1.87 acres. Slide number 30. These are from your staff calculations. So when the B3 requires a 40-acre minimum, which is the way it was set up, They're asking for an apartment site with 114 units per acre on 2.7 acres. It's not even a tenth of what they need in the district. The natatorium is going to be under separate ownership, and that's going to be on a parcel of 1.87 acres, 1.087 acres. They don't even have 1/30th of the land mass that they need for the natatorium site. And even if you combine the two of them, they're just over 10% for what they need for the site. 10% of the 40-acre minimum that's required. The FAR, let's talk about the FAR. To come into the B3 district, he bought into the B3 district knowing that the FAR limit was 0.5. If you're using all 18 acres for this proposed development, they are nearly double that. They're asking for nearly double the FAR at 0.95. If you're using just the apartment site, the FAR for just the apartment site by your staff's calculation is 3.08. That's 6 times what's permitted in this district, and that's going to be a separate ownership. If you're using the natatorium alone, that's 1.27, which is more than double the permitted FAR in this particular district. So they're blowing way through the FAR figures. Now, the argument that they've made is that, well, we've got the golf course. We should count the golf course in the FAR. Now, understand, he's walking around telling the community, I can build Home Depot on the golf course. I could put up 150-foot tall buildings on the golf course. I can load the golf course up with anything that's permitted in the B3 district. Your village board was so frightened of the ability to develop the golf course that they restricted R4 on the golf course, but they didn't restrict anything else. And he's standing before you saying, well, give us credit for the FAR on the golf course. We've got control of it for a while, and when we lose control, you know, maybe somebody will develop it, maybe they won't. But the golf course is not permanent open space, and the FAR problem is going to be there forever. If you approve a plan with an FAR that's 30 times or 6 times what's supposed to be permitted, or 10% of what it's supposed to be on this site, it's going to be there forever. The FAR of the golf course is not guaranteed forever. How do we know? Frankly, we don't. Your staff, at our request, asked for a copy of the ground lease. They didn't get it. I asked for a copy of the ground lease. We didn't get it. We know that Michael Butler lost his interest to creditors, so we don't know who holds his interest. And Frank Butler died. We don't know who holds his interest. And we have no idea what the terms and restrictions are associated with the ground lease. What can and can't be done on the golf course. We've got no idea because there's been no transparency from this applicant regarding what's going on the golf course property. That information has been withheld. It's not before you. Density standard. By your staff's calculation, next chart, the acreage that would be required to put this level of density in just for the apartments would be 33.6 acres. They're proposing 2.7. 33.6 acres would be required for this level of density under the village code. Now understand, this is an applicant who bought property, now tries to cram in a land use with a density that requires 33 acres on a 2-acre parcel and says, it's a hardship, and believe me, it's not self-imposed. I didn't cause this myself. That's what's before you. He bypasses these violations of the B3, claiming these are waivers. We've already dealt with the fact that you can't waive provisions of the B3 parking. It's a different section of the code. I think Mr. Rathje raises a good point. The language that is in your ordinance, next slide. This is not supposed to be considered a planned development. What does that mean? I'm not sure. Your planned development ordinance doesn't have any standards. It's unlike any other code I've ever seen. Every other code that I've ever seen for planned development, you have to seek a special use to obtain a planned unit development. There are standards that you have to meet in order to prove it up. Your planned unit development code says, well, just do it as an overlay. And there's no standards as to how you get it. So if you process a planned development in any district in this community, you just act as though the standards don't apply. What it is it's, at best, it's confusing. At worst, it's individualized, codified spot zoning. Because you blow all of the standards out of the district and you just say, you know, ignore the FAR and ignore the lot coverage and ignore the density and all of these things. It's a planned development. We'll just waive them. and we'll take credit for the golf course. Parking variations, we've already discussed the locations, slide 33. Quote from the Westmont zoning ordinance specifies where they have to be on the same lot as the building use served. Such facilities have to be within 600 feet if they're off-site. Mr. Rathje already addressed this. Next slide. Section 105 provides that they shall be on the same lot in possession of the same title record holder. That's not the case here. If they're going to be off-site, you got to have a covenant running with the land that must be recorded. So each of these sites that are on the list that have been provided by Mary Ann, you would have to have restrictive covenants recorded on those parcels of property that restrict them to the use associated with the natatorium. They couldn't have multiple uses under your code. There's no variation requested for this, and yet that's exactly what they're proposing. Number of spaces for the natatorium. We've been all over the map regarding how many spaces are required for the natatorium. Your staff started with 600, and then they changed it from being a swimming pool to a stadium or a gymnasium, and the number went from 600 down to 280. But what we didn't do is we didn't take a look at what natatoriums actually required. Your first staff report said 600, the second staff report said 280. KLOA, in their report, this is on page 24 of the report that the petitioner gave you, KLOA said that they will have 600 to 700 cars for the large swim meets. We're proposing 280 parking spaces for 600 to 700 cars on the automobiles. Why such radical fluctuation? Because you don't have a natatorium land use anywhere in your code. It's not defined anywhere. And you don't have a natatorium parking requirement defined anywhere in your code. You're trying to define how many parking spaces will be needed for a land use that you don't have and that we're being told doesn't exist anywhere in the state of Illinois. So how would you go about defining what the land use is going to be? You heard of 2 natatoriums where these events that they want to hold in Westmont are being held. One is the IU Natatorium in Indianapolis. So we went to Indianapolis. Here we go. This is the IU campus in downtown Indianapolis, and the natatorium is depicted in blue. We've given you a report at tab 19. It was done by Hitchcock Design. They actually measured all of the parking places that are in place for the campus that are within a half mile, which is the pedestrian walking distance to the natatorium. They then quantified all of the parking by actually counting the parking spaces that were visible, counting the parking spaces on the top floors of the deck, and multiplying by the decks. They actually have an office in Indianapolis, so we got this done. The first chart shows the location of all the parking spots. Second chart, superimposed over an aerial photograph, they've actually assigned a numerical number to each one of the parking places, along with quantifying all of the parking that's available within a half mile of the natatorium. There's over 13,000 parking spaces on this campus. Let's go to the next exhibit. This is what that campus area parking would look like in relationship to the natatorium at Oak Brook Hills Resort. You can see it right there. We've placed the natatorium exactly where it's supposed to be and where all the 13,000 parking spaces would be available in proximity to the natatorium at IU. But we wanted to focus on the ones that are immediately next door. Next chart. This chart shows site number 74 and 75. These 2 parking decks immediately adjacent to the natatorium have 2,560 parking spaces. Now, if you just look at the parking availability on the site the applicant says is being used for their proposed use currently, what you have is this. With just 2 adjacent decks and over 2,500 spaces, divided by the 4,700 patrons at the IU natatorium, it's 0.53 parking spaces per seat. If you use 0.53 parking spaces per seat for 1,400 seats, which is what your staff thinks is available at this site, you come up with 744 parking spaces for the natatorium. And if you use 0.53 spaces per seat times the 1,200 seats that the applicant says they're going to use, it's still 636 parking spaces, very close to your staff's original projection for what a natatorium needs. Now, we went to the second facility. The other site that was testified to during the previous public hearing is the Recplex. Now, this site is located in Pleasant Prairie, just outside of Kenosha. It's a 485-acre recreational site that's owned by the village. You can see at the southeast corner, you have a large recreational facility that incorporates the natatorium. Now, we counted up the parking spaces there and spoke with the director. You've got a copy of the report that we obtained from the natatorium that's located at the Pleasant Prairie rec location. They have 1,082 parking spaces divided by the 650 seats that they have at the facility that's currently being used. Now again, the facility that's currently being used, and we want to take those events from this facility, only seats 650. They're providing nearly 1,400 seats by your staff example. So Pleasant Prairie, what they've provided is 1,082 parking spaces divided by the 650 patrons equals 1.66 parking spaces per patron per seat. If you apply that to the 1,400 seats, you would require 2,324 spaces in Westmont. And if you apply 1.66 spaces times the 1,200 seats proposed by the applicant, you'd require 1,992 parking spaces at Oak Brook Hills. These are the comparables. These are the sites that the applicant is telling you is hosting the events that they want to put on this site initially with no parking. These are the events with this type of parking demand that they want to ship the overload on a regular basis to Oak Brook. That's what this application is about. Now, if you study, if you use projections, if you use the comparable of Indianapolis, the comparable in Pleasant Prairie, the original staff report, the KLO projections that they're going to have 700 cars on this site, you need between 600 and 700 cars for the natatorium alone. So any suggestion that 280 is the right number, we're looking for the right number, 280 parking spaces, they don't have any natatoriums that equate to that. The facts show to the contrary. Size of the spaces. This is a parking variation. They have to prove to you how many spaces they're creating. So they give you a parking report, and their site plan that they've posted here shows their parking spaces are 16 feet deep when they're required, even at minimum for a long-term parking space, to be 18 feet. And if you've got a foot overrun, your sidewalk's supposed to be 7 foot in depth. They've got a 6-foot sidewalk. They're cramming in parking spaces that don't fit. And you can get a whole bunch of parking spaces if they're the size of a microbus. But you can't get the regular parking spaces if they have to be 10 by 20 per your code, and they haven't asked for that variation. And then we go to the apartment building, because most of the parking spaces here, most of the parking spaces are in the apartment building. They haven't even given your staff dimensions. We don't even have a plan we can analyze for the 700 parking spaces that are in the apartment because they haven't given you anything. Give us a parking variance. We don't know how many we're going to get, and we don't know what size they're going to be, but please give it to us. We've proven it up. It's really a hardship. That's the case that they've presented to you. Now, that brings us back, after we've discussed parking, it brings us back to the easement. You'll remember we had a quote at the beginning where your engineer said back in March, we need a plat of an easement vacation. What was he talking about, and why isn't there anything in your record about vacating an easement? The traffic consultant said this, slide 46. 46 is in the March 22nd letter. That is a tab in your binder. And that brings us to the covenant and easements. Note, this goes all the way back to tab 4 that we provided you. The easements that were granted back in 1985 state, as is posted on the board, each owner hereby grants to every other owner. This is the golf course owner, the office site owner, which is now the residence, and the hotel owner. Each owner hereby grants to every other owner for the mutual benefit of their respective sites, blah, 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 an access area easement. I've bolded that. Access area easement, remember that word. For ingress and egress to and from the sites of the owners, for passage of vehicles, and accommodation of pedestrians, that ingress and egress over the hotel site for the benefit of the office building site shall be limited to passenger motor vehicles and pedestrians. Okay, let's figure out what that means. That's tab 4 in your binder. They go on in the same document. It is the express intention of the golf course and office building owner that the easements, licenses, and covenants and restrictions set forth in this instrument be and hereby declared to be easements, license, and covenants, the benefits and burdens of which shall run with the land, and shall inure to the golf course site and the office building site and the respective successors in interest and assigns of the fee simple title to the golf course site. That's my clients. These easements run in favor of my clients. Next. Also tab 4 in your binder, this is paragraph 7F. In the event that the golf course site and the office building site or any part or parts thereof cease at any time to be under common ownership, the benefits and burdens of the easements, licenses, covenants, and restrictions granted and reserved herein shall continue to be binding upon each of the sites automatically and without the need for any further additional documentation. It inures to the benefit of these residential developers, and you'll remember that this particular document was litigated in 1994, and the owner of the hotel insisted that you couldn't use this easement for residential use of the 16.9-acre parcel, and the court said, no, you're wrong. That easement runs in favor of residential use of the 16.9-acre parcel. Now let's take a look at where these easements are. First slide. This is the exhibit that's attached to that 1985 agreement. And you can see that it depicts in the center, this is tab 22 if you want a closer look in your binder. The big area in the center, that's a parking lot. And if you look closer, that's what it says. The access area easement is over the parking lot. Now, there's two other easements that are referenced. Yes, sir.
Could you please start again, because I interrupted our attorney and he wants to hear you.
Okay.
I did catch it.
Okay. The key point that I want to make is that this access area easement exhibit is attached to the 1985 document that's tab 4 in your book. The area that was granted an access area easement covers the entire parking lot. It covers the section of the parking lot that dips down. It covers the parking lot that's to the north of the hotel building. And then the access easement for the entry road covers the entire entry road. And then the entry road that they're about to tear up covers the access easement that runs right in front of the hotel. And that's what it looks like in color. Let's go to the next slide. These are the areas that have been granted access easements for driving vehicles and for pedestrian use back in 1985 that the court said are enforceable by an owner of the residential development. And their easements are pertinent, they run with the land, and they run in perpetuity in favor of my clients. Now, note tab 9 in your binders. This is from the court decision. This is what the appellate court, 2nd District, said when they upheld these easements. We've examined the easement area and find it to be, or the easement agreement, we find it to be complex, very thorough, and remarkably detailed. The overall tone of the document could be said to reflect the contemplation of the parties at the time that the offices would one day be built on the site and that the easements would be used for office development. What it does not show is an intent to indefinitely preclude the use of the easements for residential development. The next quote. While the agreement unmistakably prohibits use of the easements for industrial and hotel-motel development, it is silent on the matter of the easements vis-a-vis residential development. Absent ambiguity regarding this issue in the easement agreement, there is no need for us to consider extrinsic circumstances, and we decline to add a term which the parties themselves did not see fit to include in the form of a covenant. The trial court did not misinterpret the easement agreement when it found that it did not prohibit use of the easements for residential development purposes. That's the ruling of the court. Now, to complicate matters, we've provided at tab 23 the title policy that typifies what the owners received when they purchased their condominiums, the townhomes and their duplexes. The title policy, in this case, that's our president of the association. He provided his title policy, and we gave you the Schedule A. It says the land referenced in this policy is described as follows. They have a legal description for the individual site, and then they say Parcel 3, perpetual non-exclusive easement for ingress and egress for the benefit of Parcel 1 and 2. The easements that they have insured that my clients own have been insured with the purchase of the property, which means you have a lender that has an economic interest in what was covered and insured under the title policy, and you have a property owner that has an insured interest in preserving the property that is guaranteed for coverage. And this particular one was almost an $800,000 purchase, very typical of what Mr. Marus specified. So if you've got a 30% loss, I think that you're looking at a claim against the title company, or the title company is going to defend that particular easement, either on behalf of the bank or on behalf of the property owner, or both. The easement is an interest in property by law. Now, the residences of Oak Brook Hills, they own a full access easement over almost the entire parking lot. The natatorium is an obstruction. The apartment site is an obstruction. Here's what the Illinois Supreme Court said. This thing's going on 60 years ago. It's in Schaefer versus Bernstein, slide 56. The rule obtaining in this state is that the owner of a right-of-way for ingress and egress has the right to use the full width of the area or strip having definite boundaries, unhampered by instructions placed thereon. The defendants have no right to maintain a gate across this right-of-way, nor do they have any right to place obstructions of a permanent nature upon the easement. So what I'm suggesting to this panel this evening is the only way to get to the bottom of what's going on here, because none of this information was provided by the applicant, none of this historical record of the controlling documents was uncovered. They didn't bother. We know that when they took title to this property, they were given a deed that said, you are subject to this easement. I'm going to give them the benefit of the doubt and assume that just in their haste or lack of interest, they did not understand or they didn't read the easement agreement. But this easement agreement is a legal right, and it's a private legal right. This is not a subdivision. The village didn't subdivide this property. The three owners created these restrictions and easements and cross-references for each other. They intended these things to run in perpetuity in benefit of each of the three parcels of property. And a court's already issued a final judgment that this is final and enforceable by residential use. This easement prohibits the development that this group has been working on for the last 6 months. This should have been uncovered at the very first of the due diligence by this particular purchaser during the course of the purchase. If it wasn't, shame on the counsel who was representing them. It should have been uncovered during the due diligence review of a site like this that has an extensive litigation history as well as extensive entitlement and approval processes that involved all sorts of legal disputes. It was not. We stand here today, though, with full knowledge of this legal document and the fact that my clients have an insurable right to walk across that parcel uninhibited by any obstructions, and that they stand to lose as much as 30% of their property value if they let this thing slip away. They're not going to do that. I'll answer any questions that you may have. Thank you.
I would just make a clarification for the benefit of the commissioners regarding the off-site parking that's been referenced. The applicant has stated that they were willing to provide off-site parking for the large-scale events. The attorneys for the neighboring property owners have asserted that that off-site parking wasn't published properly as a variance because it doesn't meet the standards. In reality, it's my opinion that the parking variance which is sought is for the parking provided on-site, and staff has calculated a deficiency without any consideration of off-site parking. The off-site parking isn't considered at all when staff came up with the parking deficiencies for purposes of the variance. So the fact that the applicant has offered to provide off-site parking, in my opinion, and I believe in staff's opinion when they consider this, wasn't relevant to the parking variance that's being asked for. It's something the developer has offered. It's something that we are going to work on with the developer as part of a planned development agreement. So to help, I guess, allay concerns about large-scale events, but the parking variance stands based on the deficiency the staff noted in their report. And having off-site parking Again, it's kind of not part of the site plan or part of the development approval request.
May I have the attorney, please, that was just up there, address us again?
Yes, sir.
I apologize, I forgot your name.
My name is Scott Day. It's easy to forget.
All right. I'm a simple little old guy, you know, sit up here and all this. The gist of what you're just telling me is your homeowners in Oakwood or Oak Brook there.
It's the residences of Oak Brook Hills, which is a
Yeah,
condominium.
the residents, right. Okay, because I remember I was on the board creating it, and it's really been a tremendous improvement for us. Anyway, your assertion is that by right of covenant, they have complete and full access to this entire parking lot,
Correct.
and they have a say-so if anything is to be done to this parking lot.
Their easement rights prohibit the owner of the underlying fee inserting any obstruction that would limit their ability to walk on the site or drive on the site. That's what the Illinois Supreme Court said.
All right, but before any changes could even be made, they have a right to deny those changes.
Correct. And the village cannot authorize by your police power the extinction of a purely private property right. This is not a public easement that was created as part of a subdivision process. This is purely a private property interest. It is recognized by the courts of this state as an interest in real estate. You don't even have the owner of this property by your definition of the code before the village. In order to file for a variance in the village, you have to be the owner of a freehold estate or be in exclusive possession of the property. That's what your code says. You don't even have that. You've got an owner of a property interest in this parcel who can prohibit any building being constructed on it that's not even part of the application process. And the village is powerless to extinguish it unless you follow the constitutional rights and seek to extinguish it by eminent domain. And there you would have to prove a public purpose and provide just compensation in order to do it. It's the fact of where we're at. I know we've hit you with a bewildering history of control documents in this case. You've got nearly a 35, well, we're dated back to 1971. We're in excess of 40-year history. But the controlling documents need to be reviewed by an applicant before they waste the village's time with zoning applications, and if they fail to do it, shame on them. But the entitlement process requires an analysis, not just of what they want to do now, but what the village did historically in creating this parcel. This is a one-of-a-kind development in the village of Westmont. I know from reading the newspapers, this is something that the village desperately wants to preserve. And you're talking about an applicant that is trampling on the rights of the neighbors from the inception of the development and seeking to insert a whole bunch of intense uses that contradict the code without even proving up a hardship. It's like, if you want the natatorium, you better get ready to swallow the hotel, but boy, we're going to give you a bunch of tax money. That's what's being sold here. And it's not legal. They haven't proven up variations. They want to make a bunch of money. I understand it. They're fine people. They're fine developers. They're looking out for their investors. But they're not doing their homework. This isn't a thorough application. They haven't crossed their T's and dotted their I's. And that's a silver bullet. This particular neighborhood can stop this development. They don't even want to talk to the neighbors on this. Neighbors said, you know what, if you want to move the natatorium out of this area, we can probably negotiate an agreement with you. If you have to have an apartment building and the village wants the natatorium so badly that they've got to have an apartment building, stick it at the southwest corner of this parcel of property, carve off 2.7 acres. You know, if you have to redo the stormwater, redo the stormwater. And we know you're going to have to get permission from Jory and whoever the heirs are currently, and we don't know if that's permitted under your lease or not because you won't tell us. This shouldn't proceed this way. The village shouldn't be doing it, and the residents that have a $40 million investment should not have to suffer at the guy who walked in with an $18 million bargain basement purchase and have him try to diminish the value of their site. They shouldn't have had to do all this work to uncover why this is an illegal application. They've spent thousands of dollars getting to this point. This work should have been done by this applicant, and these disclosures should have been forthright. They weren't. Where we're at now, we are asking you, stop this process. Shut down this application. Send a recommendation to the village board that we cannot legally approve this. There are easement rights that are in our own development agreement that we negotiated back when this thing was created that prohibit this, and they're clear, and they've already been passed judgment by the court. What we're asking is stop this particular group of residents, the voters of Westmont, from spending all of this money on an application that can't be approved.
Thank you. I would ask clarification from the attorney. Speaking to you, John, I'm getting the impression that legally this should not even be before us. Now, gentlemen, the attorney is asking for us, in essence, to put a stop to the entire petition.
We can't do that.
I don't know if we can legally do that.
Well, I
But-
believe his assertion was that the village can't unilaterally interfere with easement rights that are rights between private property owners. And in that sense, he's 100% correct. However, the question becomes whether building a structure on the property in fact interferes with an easement right for access. When the easement was granted, to my knowledge, there was no parking lot there. There's now an approved parking lot with cars galore and probably curbing, islands, et cetera. That is an obstruction. Is that an obstruction that materially interferes with the access of the adjoining property owners onto the site or through the site? I think a court would most likely say, no, it doesn't. The residents still have access through the site pursuant to the easement. I think a fair question can be raised whether an apartment building in an natatorium, which maintains drive aisles, et cetera, materially interferes with the easement rights. Fair question. He talked about obstructions in an old Supreme Court case in Illinois that said you can't obstruct an easement right. And he's right, that's what the case said, but I think that talked about like a gate or something that prohibited access along the easement. I think the question is whether a building prohibits access where there are other drive aisles that would permit residents to walk or drive throughout the site. I'm not going to answer that question tonight. I don't think you have to answer that question tonight. I think the applicant can address it if he wants to, but I think you can and certainly should, if you're ready to proceed tonight, ask your questions, consider this, but I think it's a legally viable petition that was presented to you for zoning relief, and you can consider it, and if this ends up in litigation, then you have to let the courts hash out those questions.
Let me ask you this question then, John. Would you be ready to give us legal opinion at a later date if you had more time to think and study on this?
I don't think it's my job to answer a legal question that they
All right.
raised about whether the easement has been violated. I think you have enough to make your recommendation and send this up to the board one way or the
Okay.
other.
I'm satisfied. Thank you very much. Will there be anybody from the public who will speak on this issue? Please, come ahead. Don't, you have no problem with this.
Okay. I'm Mary Ann Kaufman again, and I just want to clarify, Mr. Day compared the natatorium at Westmont to the Recplex in Kenosha, Wisconsin, which is where we currently go for our state meets. The Recplex is 300,000 square feet, and it is the largest indoor recreational facility in the entire USA. It is not comparable to the natatorium that we are proposing here tonight, not at all. The other one that he quoted was the IUPUI in Indiana, which last time we had one of their people who run it as one of our speakers here. And that one, too, is the largest indoor pool in the entire United States with 4,700 seating capacity. And the parking garages that you saw were not just for the auditorium, it's for the entire city that it is at. So I just wanted to clarify that because it is nowhere near, you are not comparing apples to apples when you're comparing a 60,000 total square foot building and the footprint is only about 45,000 square feet to a 302,000 square foot indoor facility which has a track. It has basketball courts. It does have the indoor pool. It has what? Oh, I didn't even know that. I didn't even ever go through the whole building to see an ice skating rink. So 2 of them. So I just wanted to clarify that because it is not comparing apples to apples. I also wanted to clarify that in Mr. Day's group, I'm sorry I don't remember your name, but the traffic gentleman quoted that I had submitted some information to the village. And yes, I did. I was asked, because, you know, clearly these off-site parking spots were just for these major events. One of them would be Illinois High School Swim Association State Meet. That would be the biggest event we could ever host if we were ever honored to host that. And it would be in November or in February. Boys in November, women's swimming in February. I mean, women's in November, boys in February. The off-site parking was just to be utilized for that if we needed it. And that would be a special event. We would know if we were hosting that meet. And currently, Evanston and New Trier host that meet. They don't take any accommodations for any off-site parking. We sometimes park at the train station and actually grab a cab to get to the school because there's no forethought to how people are going to park over there. So that is the only time we would ever use off-site parking, but I think you also clarified that. Taking the residents into consideration from the get-go, from the first time I met Peter, he had met with the residents and he had asked me to shift the building down a little further closer to the hotel on the property. He also asked me to change my entrance, and we continue to work in their best interest. Just the other day, there's, you know, windows going across the top of the building and it's going to be a smoked glass, and Peter said, you know what, I want to see what that material is and how much light's coming out of it, and we're going to make accommodations on the side of the building where the homes are right there so we can turn off half the lights if it was ever a problem. So we continue to work in their best interest, and we will continue to do that because I really want them to be happy with anything that we move forward with. And the other thing was, again, the traffic person that talked about the numbers I gave you. So, you know, leave the special event alone. That was about that's where we had that parking information for. But Jill asked me that just if we're having a regular meet, what kind of numbers are there? So the numbers that I gave her were the number of swimmers competing at the meet. There's no way, I've called everywhere. I've called USA Swimming, Illinois Swimming to try to get how many parents show up at these meets, and those numbers don't exist. So if you saw some numbers of how many parents were there, I'm not sure where you got that number from because I did not submit anything because there isn't a number out there. Just based on experience, I showed how many swimmers are signed up for a meet. It's usually a morning session. They can go 4 hours, but again, these swimmers aren't there the whole 4 hours. They come and they go. So as he stated that that he had made a statement that you know, if they all come in at one time and then they leave at one time, and that's not how swimming works. Swimming is a sport where it's not on a time clock, so everybody isn't coming in at one time and everybody isn't leaving at one time. A swimmer, there's a schedule. You can only fit so many swimmers in a schedule, and then when people are signing up for a meet, it gets cut off. And a lot of times those swimmers don't show up because we're signing up for meets sometimes 6 to 8 weeks in advance. So if a family member has something that comes up, then there is, you know, somebody else is bringing the kids. So that's why those parent numbers are difficult to show up. If we showed any type of numbers, those were just general because we're talking about the bigger events, not the day-to-day is what I was trying to show in that piece of paper I submitted.
Thank you.
Thank you.
Please, sir. I've lost count. Did I swear you in?
Yes, sir, I was here earlier.
Thank you.
My name is Brad Fisher. I live at 27 Willow Crest Drive. I will sign in here shortly. I think you do also. I want to first say I appreciate and applaud and respect the charitable approach and contribution and effort of the Kaufman family. It's admirable, respected 100%. But I think we've seen tonight, this is not about passion or emotion or charity. This is law and fact. And even your own lawyer, bless his heart, because I think he was put in a very difficult situation to try to give a perspective of what's the law. And the last time we were here, this board said you wanted to see more data, more facts, look at it, and I think that was very fair. But what I saw tonight, and I'm not a lawyer, don't claim to be, but what I saw was fact and law. And I would ask you in your own conscience, if this board reverses itself and says to move ahead, because last time, if I remember, you all voted respectfully in your own positions, but what the vote was to not, how, based on what you saw today, could you reverse yourself and recommend this to move ahead? There's enough question, enough doubt, and enough, from what I can see, law that would cause reasonable doubt in your own mind that would, I don't understand how you could even remotely move ahead.
Regardless of how we vote, it will move ahead.
I understand, but recommendation to
Okay.
support. Thank you for the clarification. Excuse my passion. Thank you.
I saw this gentleman first.
I was not sworn in.
Okay. I swear that any testimony you give this evening shall be the truth, the whole truth, and nothing but the truth, so help me God.
I will.
Thank you, sir.
For the record, my name is Tony Sienkiewicz. I'll sign in real quick. I am the aquatics director at University of Illinois, Chicago. Came and wanted to show my support for this wonderful project. I've been at UIC for almost 4 full years. What Marianne had just talked about in terms of sessions is absolutely true. My office is in the physical education building, and we currently have a parking lot of 846 spots across the street from the pool. Aside from state meets and championship meets, the past few meets I've gauged and looked at parking. I work with parking all the time. We've only filled between 275 and 350 spots per session. So, you know, based on the parking spots, we would be well under the maximum for parking. I know people are always asking in terms of funding. You know, it's never been done in Illinois. Why hasn't it been done before? Well, quite simply, it's money. No one wants to pay for it. I know the Recplex has been referenced. The only reason why that addition, the pool itself, was brought about was that there was an $8 million donation paid for by Uline to put that addition on. I have that off of Kenosha's website itself for the commerce. In terms of the hotel, I know for a lot of events, especially for, you know, swim meets, I get emails from coaches all the time, 4, 5, 6, 10 months ahead of time. Do you have any recommendations for hotels? We don't want to be driving back and forth, you know, to whether it's Wisconsin or Indiana or even the suburbs from the city to have their children rest up, because it's definitely worth their parents' while to have their kids be able to perform to their peak. So in terms of, you know, the hotel and parking, a lot of those parents that would be at the swim meets would also be, you know, staying, so there wouldn't be excess parking overflow. They would be cars that wouldn't be, you know, either be using the hotel and then the auditorium at the same time. So in terms of sessions, there wouldn't be that much overflow in parking. And then in terms of backtracking towards the pools in Indiana, most of the pools, the long course pools, the 50-meter pools in Indiana that are utilized are part of high schools, so they're paid by taxpayer money, and that way, you know, events such as our long course state championship meets, which are generally in the summer, for age group for 14 and unders, and then for seniors, which are 15 and up, are generally held at the Recplex or Indianapolis because we can't accommodate the seating itself. For Mary Ann's project, the 2,500 expandable seats in addition to the over 1,000 seats would definitely be more than accommodating, so we can drive and attract those events back to Illinois. And I know I watched some of the minutes from previous meetings that we've had for here. Some people were contesting a Starbucks. I get parents constantly asking, where's the nearest coffee shop? I know that would certainly flourish. So whoever's talking about a Starbucks not being able to make it, they'd be out of their mind. They'd be swimming in revenue. So all in all, I mean, I think that putting this in would be a tremendous asset to Westmont, not only bringing events back to Westmont, but also attracting, Olympic athletes. I work with Olympic athletes. They come to Chicago. I work with, pretty much everyone other than, Michael Phelps, because he likes to train in the Baltimore area. But I get emails from the Olympic Training Center when they're coming to the Midwest, and, I make sure that they're all taken care of. But all in all, that they would instead probably be coming to this Westmont facility because of our apartments, and I know that they would probably more than likely want to stay in those apartments to train at an easier location versus driving around in the city because traffic can be kind of crazy. So, with my unique situation and my job, I definitely think that this would be a wonderful asset. It would be a rival for UIC, but the swim community is so small. I'm a huge proponent of the growth of swimming, especially in an Olympic year like this. There's an Olympic bump, which is an increase in all types of interest in sports. You can never have too many people in the sport of swimming, so this would be a wonderful opportunity, and it would be the crown jewel of Midwest in terms of swimming. Maybe it wouldn't be as big as IUPUI, but we certainly wouldn't have the traffic and the congestion, and people wouldn't have to drive all the way from Illinois, even southern Illinois, to go to the Recplex or to Indiana for their state meets, and be able to keep that revenue in the state.
Thank you.
Thank you so much for your time.
Will there be anybody else for Mr. Dubine?
Thank you, Chairman. I'd just like to clarify some of the statements that Scott made with respect to the legal component of the easement aspect. And did we do our due diligence? Of course we did. Dan is a land use attorney that we're using on this and another local zoning effort. However, when we acquire assets on a national basis, our law firm is K&L Gates. We use their Charleston, South Carolina office for contracts, and then our primary partner is a land use guy here in Chicago. One of the questions I asked him was take a look at it. Eventually, we're going to be into Westmont, looking to build something. Is there anything in here that says, that prohibits me from doing that? And he said, no. There's easements, but you're not going to obstruct them from getting across the property. So I think he's kicking up a lot of legal dust, trying to create an outcome that would be beneficial to his clients. For that, he's advocating for his clients. I can't blame him. I'm not an attorney. Law school was the worst day of my life, unapologetically. I'd be terrible at it, but we're willing, and as I've said many times, we're too dumb to quit. This is not something that we're going to quit on, based on a bunch of legal dust tossed in the air by an opponent. We're here to see this through to its completion. Thank you.
Thank you, sir.
And this is just in response to a question that Mary Ann raised just a moment ago. Okay, this is tab 18 in your binder. This is a letter that Mary Ann sent to your planning staff. Your planning staff wanted to know how many people are going to attend the natatorium. What kind of events are we talking about? When KLOA said you're going to need 700 parking spaces, this is what they're looking at. The Illinois Championship in March, 500 swimmers per session, up to 1,800 swimmers total at this event. 400 to 500 parents per session, 7 to 10 sessions total. This is one event. You've got 1,800 swimmers and 400 to 500 multiplied by up to 10 times. You're going to need 700 parking spaces. They can't make these facts go away. The Illinois Championship, 400 swimmers per session, 6 to 9 sessions total, depending on the meet, up to 1,100 swimmers, 400 to 500 parents per session. So once again, multiplied by up to 9. Sectional in July, 450 swimmers per sessions, 7 total sessions, up to 1,200 swimmers, 400 parents per session. November invite, 2,800 swimmers at the event. But 250 cars, 1 car for every 10 people will be fine. These are the numbers that Mary Ann submitted to the village. So they can't have it both ways. It's not, we're a small little natatorium. We're not going to bring any people in. When they ask your staff who they're going to bring it, this is what they're talking about. Their own consultant said they need 700 parking spaces for these events. That's all we want to bring up.
Thank you, sir.
Again, these are the special events, those 4 to 6 per year. Also, just to clarify, this is actually not my typeset, and this isn't exactly what I sent in. This is something that was retyped. But just to clarify, these are those special events. And yes, we already made it very clear that those would be big events, and we are, prepared to deal with those events, just to clarify.
Ms. Kaufman, are you denying those numbers? Are those numbers inaccurate?
You know what? I am not, I just know the typeset is different. I'm not denying. All I'm saying is, yes, I agree with him. These are those big meets, those exception meets that we have talked about, not day to day. Okay?
That's all I need to know. Oh, I actually pointed to the lady behind you. She's prettier than you.
I was sworn in earlier. I'll be very brief. I'm a swim mom. I've attended these events. I personally took 5 children.
Would you sign in, please?
Oh, sure. I personally have taken 5 children to these Illinois state swim meets the last few times. We carpool. I know this gentleman mentioned officials too. Officials are parents. There's siblings. I have 2 children who swim at the same meet. So these 400 or 500 participants never have 400 or 500 cars. I just personally witnessed it. And I just want to attest to what Mary Ann also said about the recplex. That member parking is gated, and we cannot use it for swim meets, so it was included in his numbers, but we're seeing a lot of smoke. This is not reality. I'm attending these meets. I wanted to speak as a swim mom. Thank you. I also want to speak as parent for the schools. The revenue that Peter showed that will go to the schools, the incremental tax revenue, I believe is really important. One of my friends is a 3rd grade teacher at J.T. Manning Elementary. She said that money is desperately needed. So I'm grateful for the opportunity that this group is presenting. Thank you.
Thank you.
I just wanted to clarify, again, my name is Rick Faywell. One issue that made us sound like we're sneaking around trying to put in as many parking spots as possible. Man, if I was as bad as you guys characterize us as being, I'm gonna go home and feel terrible about myself tonight. Anyway, it's a small point, but the parking spaces are 9 by 18, and there are some 9 by 16, which was part of a discussion that we had with Jill and our civil engineer, and they're only in places where we're allowed to do that. So we do have 9 by 18, and we do have 9 by 16. There's a 2-foot hangover in grassy areas that are bioswales. It's all perfectly legitimate. There's no hidden agenda. We're not trying to cram in more spaces than we deserve to make.
But they didn't mark this.
The other point I'd like to make, and it bears repeating, I know we've said it, but parking is also something that turns over during the day. When I did Navy Pier, we started out with 1,000 spaces for 270,000 square feet of convention, 70,000 square feet of meeting space, as well as Children's Museum, IMAX Theater, all the retail, South Dock, and the Navy Pier Park outside. Now, that doesn't sound like a lot, but those spaces turn over 4 or 5 times a day. That's not unusual. There, they charge for parking, and so it's actually one of the largest revenue producers. But my point being is, again, we're always comparing to places like in Wisconsin or in Indiana, where it's a single-use type of facility, sports, particular events. This is a mixed-use facility. So during the vast majority of the days of the year, the natatorium, as an example, will have limited amount of people using it and parking for it, and there will be events going on golf will be going on, but people come and go for golf. People come and go for conferences. People come and go for the hotel. So again, when we talk about parking, we're always talking about it and adding it together. We're never thinking about the fact that it turns over, that it's mixed-use development. I just want to make that point. And I want to just clarify one other thing. We put together this spreadsheet, and maybe it was too much, but I wanted to sort of put a chronological order to the parking discussions. It started with a May 18th meeting and kept working forward. As I mentioned, we were working with staff on the hotel comparables and the housing comparables. And more or less, we're at agreement with the housing. We've more or less, because what we were asking for was 449. What they were saying is, no, it should be 505 by the code. Fine, 505. With the natatorium, again, the numbers are all over the place, but the code is fairly clear. 285 per seat. They came up with 1,400 as a capacity. There's 1,200 seats and an additional 200 people participating in other events. So we bought into the parking number for the natatorium because, again, it's Westmont code. So the only real number left was the hotel. And to us, the variation between 2.5 per room and what we were seeing in the marketplace, which was closer to 0.9, 0.8, up to 1.5, it was worth at least discussing and looking at and thinking about, because we do think that 965 is too many for the hotel conference center. So we're really, like I said before, we're really getting pretty close to agreement with staff based on the Westmont code. So I'm not trying to sort of use the Westmont code when it's convenient and then argue about it when it's not. But in a way I am. But in a way, so are they. So anyway, I think we're closer than we think.
Yes, sir, if you would, please.
Hi, my name is Don Bartecki, and I've worked a lot with the Westmont, I've worked a lot with the Westmont Swim Club. The Westmont Swim Club used to swim out of the Westmont High School. We recently built a facility down in Willowbrook. It's a 12-lane, 25-yard pool. It doesn't host meets. So how many parking lots does it have? Does it have? 53. There are 53 parking lots, and that services that facility. This is a 10-lane, 50-meter pool. That is a 12-lane, 25-meter pool that hosts a swim club. So you're asking about what's going to be there when there isn't a special event. Those special events, you made it sound like they were on one day. That one event, I think it was 500 swimmers, those are over 4 days, Wednesday through Saturday, Wednesday through Sunday, Thursday through Sunday. So it doesn't all come on one day where you're going to have 500 people in 7 sessions. That's over many, many days. So there's not that rush of that many people, 4,000 people, and they make it sound like. And when it's not in use, it's been proven because the team that swam at the Westmont High School, they use 53 spots, and that is the parking that they use, and there's no problem with that parking. So not to overemphasize it, but I think that that was a lot of issues about parking, but I don't believe you'll have that parking issue. And I think you'd be really foolish to pass up the generosity that they're having within there, and plus the opportunity cost, because I know you're trying to replace that pool. I wouldn't like to see a pool replaced, but you could really do something with that area at the Westmont High School also, if there wasn't a pool there or there wasn't a need of a pool there, because you now have this within the park district.
Thank you. Is there any further public yes, ma'am. I hope you're not talking about parking.
Really briefly.
Please.
Hi, I'm Susan Casey. I live in the Oakwood subdivision on Williamsburg Street, and I work in the city of Chicago. I grew up in the city of Chicago. I leave for work every day 2 hours early to get a parking spot in Chicago. when I hear all this about the parking, I feel like I'm going back to Chicago. Westmont is like my little haven away from the crazy life of the city and all this parking and all this traffic. I run down 35th Street every day almost, run around the Midwest Club. There's no sidewalks there. There's already some traffic, and it's really hard to do. And I'm imagining with all these special events, 326 apartment buildings with, who's going to come visit these people? Where are they going to park? Where are they going to be driving in the Oakwood subdivision and parking on our streets? I know my kids live in the Gold Coast. When I go to the city to see them, I drive around for a half hour looking for a parking spot. And I feel like Westmont, with this going to happen, I feel like Westmont is going to become like a mini Chicago. I might be wrong, but I need to go home. I'm really tired. I have to go to work tomorrow. I work for CPS, and I need a good night's sleep. So, good evening.
Thank you. Any further comments? Chief, is there anybody in the other room that would care to? Okay. Public comment is hereby closed. Commissioner Bartel.
Well, my first question is, if the residents are supportive of moving the natatorium to the west side and the apartment building over, why is there resistance to that? That's the compromise I'm seeing that might work for everybody.
Please.
From a legal perspective, from an investment perspective, the golf course is on a long-term ground lease, so we have long-term control of that land, but it would not be feasible to finance an apartment building on a ground lease that has, I believe, about 30 years left on it. Furthermore, Mr. Day mentioned that, oh, geez, you can just move 2.7 acres and shift it. That's not reality. Part of why the apartments work where they do when not over there is the efficiency of the adjacency to the hotel, the ease of use of shuttling people, and then it would destroy the golf course. I mean, that was the text amendment argument that this very commission made when they recommended against it. I think the open space use is great. And furthermore, the adjacency of the natatorium, the apartments, and the hotel, as Mary Ann earlier testified, all work in conjunction with one another. And the retail, having the coffee shop next to the natatorium works real great. Having it across the golf course doesn't work at all.
Another concern that I had, because we had discussed that at the very beginning when I first met with Mr. Dumont, Peter and I discussed it, and my concern was that the Circle Drive and coming off of Cass Avenue, that would be the first stop. And when we do have a swim meet and we have, usually parents drop off their kids, they have an hour before their child is actually going to swim. I was concerned that at drop-off, it's just too close to Cass Avenue and the safety with kids being dropped off that close to a turnabout and what's going on there. So I had asked that it not be put there because I was concerned.
Well, I have to tell you, I think there's some positives to all of this. The increased revenue, the better landscaping. I think the swim venue, the natatorium, is extremely generous, and I think it's something obviously that's needed. And all of the letters, I won't say all, most of the letters that we've read support that. What I don't hear is the support for the apartments. And is there a way, if the revenue is so high for selling the rooms in the hotel, why couldn't that help to subsidize the natatorium? Why, in other words, separate the project and have the natatorium and the hotel selling out because of the natatorium and not necessarily the apartments? It seems like that's the sticking point with the residents.
To answer your question, from a subsidy perspective, the hotel doesn't have any room in its operations currently to subsidize anything but itself. Secondly, as I mentioned at the first public hearing, from an economic perspective, we're darn close to donating the land. So we're making roughly a $2 million contribution, to the natatorium project. There's an obvious reason for that. It's going to be good for the hotel. The natatorium, though, as Mary Ann earlier testified, to achieve, its optimal position in the swim community, needs the apartments. Olympic swimmers, as we mentioned at the first public hearing, don't get paid to swim. They need to have a job. And despite Mr. Rathje's concerns about this not being a transitorium development, the point of pickup is at the apartment door to the Westmont train station. It's not a walk, it's a free ride. It's not an Uber, it's a free ride on a shuttle bus. So they get up in the morning at 5 a.m., they go do their hour and a half swim, they clean off, scrub up, and they hit the 7:20 train or whatever it is in downtown Westmont to get to downtown Chicago. They come back, we pick them up again, and then they work out again at night. Putting that apart from the central hotel component, first of all, it can't legally be done anyway, it can't financially feasibly be done. And part of what we're trying to do here is improve the overall resort itself. So the profitability of the apartments are helping me do things that are helping the residents of Oak Brook Hills, like replacing the tent with a permanent structure, like burying the cart storage underneath, like improving the golf course, and ultimately, we'd like to make that more of a much more upscale facility, which I can't believe hurts their home values. So the cohesiveness of the plan, is it dense in the central area? Yeah, it is. The rest of it's open, and as far as I'm concerned, as long as we control the ground lease, we'll keep it open. To me, that's kind of the quid pro quo. Is we're asking for some density, but in a very tight location where it makes sense, and we're doing so, candidly, in an attractive manner. We're not stacking a 1,200 car parking deck, that's 6 stories tall right next to the residences. We're surrounding it with apartments. The more efficient way to build apartments would be to do a double-loaded corridor. We have that on a very small portion of the building. So we're actually trying to be extremely sensitive in doing this the right way. Because candidly, it's the only way I've ever done anything. Sometimes I win, sometimes I lose. But as I tell our staff all the time, I can't stand half measures. The golf course improvements, I'm not going to do it as a half measure. If we're going to do it, we're going to do it right.
One last thing as the planner, and it's not on the screen, I thought it would be, but it is not good. You can kind of see the size of the natatorium because it's 2 pools. It doesn't fit anywhere on the west side of the site. You could change position and put the natatorium where the apartments are and vice versa, but that doesn't fit either. And the parking needs to be as close to the hotel entry for the main entry as well as conference center, and parking to the ballroom and the golf course, and likewise the parking in the center to the natatorium. So that's the reason for the layout of the site. It isn't that we don't want to move it to the west side, you just can't. It's too big as a footprint.
I just feel as though part of our responsibility here is to advocate for the residents of Westmont. And we're hearing that, their view is blocked and their property values may or may not decrease. That's to be determined. Parking on their property, the access for emergency vehicles. I think if we represent the residents, we have to be very clear about what their concerns are. And I guess I would echo some of those concerns. Thank you, Mr. Chair.
Commissioner Thomas?
As far as I'm concerned, I'm ready to see this go on to the trustees. And as far as my perception, the perception is, and it's my perception, it's not up for debate or anything like that, but the term legal dust was brought up, and I agree with that perception of how things were presented, and that I'm not an architect, I'm not an economist, I'm not a swim expert. I don't know how they run, but also I'm not seeing any barriers, quote unquote, that are going to block these apartments off from everything, and the pink paint that was painted on that blueprint was painted with a very broad brush, as if there were walls being put up. I'm interested in seeing the trustees vote on this, and go forward.
Commissioner Bill.
Yes, I have a few questions. I'm having a lot of trouble understanding the ratio of a studio to 1 to 2 bedroom. So we saw plans that were before us, which is what we're going to be voting on, and there have been so much hearsay and so many things said here and there, and I know there was a summation made that said basically, we're willing to put all this stuff in writing, but it's hard to keep track of what we would even put in writing because there's been so many different statements. So how many studio apartments are there? Are there any? I've seen 0 to 92. That's a pretty big range.
I think part of the confusion is that when people are looking at the plans, it's hard to tell if that bedroom qualifies the apartment as a studio or as a 1-bedroom. I think that's where it started. We've always had studios, or efficiencies as they're referred to in the code. And we have 92 total, 28%. I think you have it right. Since the last meeting, we sat down with staff, we went through this, and we, coordinated the numbers. So I think it's correct now. And we've always had, actually, we had more studios before, and Peter wanted fewer studios, more 1-bedrooms, more 2-bedrooms. So we did the mix based on the leasing agent's requirement for leasing it.
Okay, because I thought at the last meeting, we specifically discussed they were all 1 and 2 bedroom. I don't remember hearing anything about studio at the last.
Again, I think it was just that in the plans, people look at it and then it gets easily miscounted.
Okay.
Yeah.
Where do the apartment dwellers go to walk and exercise animals, and why are there no sidewalks to Cass? That was a strong recommendation from many people.
It's hard to see on this drawing, but there are sidewalks to Cass on both sides now, and there's a path that goes around the entire 18-acre site. It's about a 3/4 mile path that can be jogging, and that we added in pretty quickly after meeting with the residents the very first time, and they mentioned where do people go to walk, and where are these people going to go, without walking through parking lots and things like that. So that was laid out pretty quickly, and then since the last meeting, we extended it to Cass.
Yeah, I didn't see that in any of the drawings, and when I asked that question of staff, I received a negative answer on that.
May I just comment that the most recent site plan that we received on Tuesday does not show sidewalks to Cass.
Yeah, we will absolutely have sidewalks to Cass on, as a condition of approval, as a condition of a building permit, as a condition of being, frankly, intelligent. There'll be sidewalks to Cass on both sides of the entry drive.
Well, again, just to reiterate, this is part of my problem, is that we've got so many of these one-timers, it's hard to keep track of what we're really going to have and what we're not. We have to base, I've spent hours on this stuff, reading and studying this and asking questions, and it's hard when it changes both at the last minute or when it's an implied change that we may not even have access to seeing. So please keep that in mind.
I understand.
Where does snow removal take place on this property? Because that's an awful large area, and in the past, they've been able to use some of the excess parking, but I think we're in short supply on excess parking now. So where would snow removal go?
That's a great question, but we would use, if necessary, with the heavy snow, we'd use dump trucks and then distribute it outside our maintenance yard of the golf course.
Okay. Parking, could we discuss a little bit about the 700 spots and the interior? I like to bring back that term. What was it? Is that the Texas or the?
Texas wrap.
Texas wrap, there we go.
It's either an apartment building or barbecue.
All right.
Inside a tortilla.
So, can anybody drive into that building?
That would be available to residents of the apartments on an assigned basis. So, anyone that rents an apartment unit is going to, have, either, 1 or 2 spaces assigned to them. Furthermore, that's a monthly charge. So they'll have.
What keeps a swimmer, like when the parking lot fills up, what keeps people from just driving up there? Is there gates?
It'll be gated and access controlled. So if someone wanted a valet park, we'll have valets for the large events. And the valet would have a key card that can park in there. Otherwise, employees of the hotel, valets for the hotel can park cars in there.
Okay, so it is segregated off.
It'll have access control.
So
yes.
you're living there, I come to visit. So I got to park on the outside part because I don't have a fob to get in?
Or you can call up to the unit and there'll be some visitor spots inside.
And you would let me in?
And the
then
resident can
there's-
let you in, yes.
There's visitor
The
spots.
parking technology is pretty amazing right now. You can also generate a code to be used during a certain time. So, for example, if I know that you're coming to visit me at, between 9 and 10 o'clock, I can generate a code that's only good between 9 and 10 o'clock. You drive in, and then when you leave, you exit. And the code, blows up, for lack of a better term.
Okay. And John, just to clarify, so none of our questioning should take place on the maintenance site parking? Because that's not.
Likewise, then, we should not consider the maintenance site for snow removal.
No, that's
Or
the
could
golf
we?
course.
Well, he's talking about possible parking over there.
No, I mean, he can testify that that's where the snow's
Oh,
going.
okay, okay.
I think what Greg was talking about is talking about the maintenance
128
site to accommodate required off-street parking for that site.
I
I
We
understand.
didn't publish for that, so it can't be considered.
Okay.
One of the requests that I've made through staff, and I've not seen anything that would represent any type of correspondence, communication, or approval from Hilton Corporate on this. And I've heard that it's forthcoming. I've not seen that. Does that mean that there is no Hilton approval on this project? Because I would think they would have somewhat of an interest since it's their name up top.
Yeah, Hilton has no approval authority on this. We're not required.
No, support then. Let's change it to support.
If you want to make Hilton support a condition of approval, we're happy to do so. They enthusiastically support the value-add components that we're going to do on the parking lot. The natatorium is a game changer. It's going to, when we sell out in November, December, and January, because there's an event at the natatorium, right now, all the different buckets of money we pay to Hilton, they get about 12% of our revenue. They'll be
Well,
thrilled to
and-
see this.
And we need to have this scale where we weigh things, because if we're told that there's only 5 to 6 of these events and they're only 2 days, we're only talking about 10 days out of 365 that the hotel's going to be sold out. It's a relatively small proportion. So, I've heard things from both sides that, are somewhat ambiguous as far as the numbers and the terms and things like that. But, I don't know if that would make that big of a dent, but perhaps it would. You're a hotel operator, I'm not.
Yeah, if you look at, going back to the beginning, the delta, between the peak is, I think, roughly 50%, on an inflation-adjusted basis. Improving the hotel, as we've done, we've already made roughly $10 million of improvements to the common areas. It's a dramatic improvement. When we had the Oakwood Homeowners Association meeting, I walked out and then, went down to check out progress on the bar area. And it was the first night the bar was actually open, and I was stunned. I mean, the place was jumping. It was
packed.
So I'm excited about that. I mean, the biggest challenge we had there is we staffed up based on what used to happen. Now we're understaffed on what's happening now, which is a great sign to have. So, our goal is to get this back to where it was on an inflation-adjusted basis, which will be a much, much better facility.
While you're at the podium, can you tell me a little bit about, I'm uncomfortable with 5 lot divisions, because it seems to me that that's sort of a build and sell type of approach, and we're trying to reverse that effect. We've just had a major apartment complex in Westmont with 500 units or so. 60-plus owners go down to 1 owner. And now there's a lot of progress being made. It's getting cleaned up, and there's less police calls, and values are going up, rents are going up, et cetera. It seems to me that by separating these lots out, we're almost setting it up for a divide and sell kind of a thing, piecemeal. I don't understand what's going to happen with Lot 5, and why is it not a part of Lot 2 since it's all parking? That would seem to be a simple one.
Good question. In terms of the lot divisions, it's being done really for purposes of transacting with the FMC Aquatic Opportunities to provide them with the land. Basically, underneath the natatorium is going to be their parcel, including a little bit of the parking on the north side there, the 18 spaces. The parking lot and the golf course parking lot are going to be part of a common area lot that'll be used for parking. All of the hotel, the natatorium, and the apartment building are going to have obligations related to that, through a common area association that we will set up. The hotel will permanently have control of that association, so the hotel will control everything that happens, maintenance, landscaping, all of that. We're also going to contract with the natatorium for interior maintenance as a condition to that real estate transaction. We are going to, self-manage the apartments. Our intention is to own that long-term. Certainly, things change. We could sell the hotel, then that owner would have control of the association. We could sell the apartments, and they would have obligations to maintain the apartments in a first-class manner. That'll be part of the Common Area Association. As it specifically relates to Lot 5, we decided to, create that as a separate lot for a couple of different reasons. One being, if, Lou A is wrong, and I don't think he is, ultimately, we could add a parking deck there if it was necessary. I don't think it's going to be necessary. I think we're more than parked for all but those handful of events, and we've got, really good ways to handle those off-site. Alternatively, looking at it from from an economic development perspective, and as a developer, we would look at that as in the future, potentially a small extended stay hotel. And that would be, that would obviously require, we were thinking, somewhere in the neighborhood of 80 rooms. That would require us to replace whatever parking is there, plus the, whatever new demand we put in. In all reality, I don't see that happening. I think that stays as what it is. And if it's a sore spot with this commission or with the village board, we can agree to consolidate that with the parking lot and leave it parking permanently.
Okay. All right, thank you. The last thing I would just like to say thank you to everyone here who's worked hard on the presentations on both sides, and all the homeowners who have put up with over 8.5 hours of hearings, plus all kinds of local meetings and things. It's nice to see input, and too often we sit here and we hear nothing but silence, and it's nice to have some input. Thank you all.
Commissioner Van Buren.
I have no questions. I feel like my head is spinning from all the information that I've been presented with. I'll save my comments for when we vote.
Commissioner Carmichael.
Mrs. Kaufman, I would commend and thank you for you and your family's generosity for this offer of yours. Is it appropriate to ask how much it would cost to build this natatorium? Maybe within a few million of
about 15 million.
Thank you. And I guess the only question I would have, Mr. Damone, on the studio apartments, maybe I'm not a realtor and I'm out of touch, but from my college days, a studio apartment was something where the bed folded down out of the wall in the living room, and it's very efficient and relatively cheap. But I don't associate that term studio apartment with the term luxury. And could you address that?
Excellent point. Rick, the square footage on those as well?
600 to 700.
600 to 700 square feet. The reason we're using that term and not a one-bedroom is many of them, will have a cordoned off area for the bedroom, but the wall doesn't go all the way to the ceiling because it doesn't meet the requirements by code. So, you've got outside light, outside air, but that's also required in a bedroom, and maybe the bedroom is interior. So it, kind of acts and feels like a one-bedroom apartment without the wall going, to the full height of the ceiling. It's fairly common in these types of developments.
Thank you.
Yes.
That's all I have.
That's all? All right. Give me 1 second here. I also have got numbers running through my mind. There's been so many changes. That's why I'm only using pencil anymore. Mr. Faywell, with parking. If an auditorium were built and the apartment were built, how many parking spaces would be in lot, I think that's considered lot number 2, correct?
604.
Okay. To go back to parking, right now, our hotel, our usage for our hotel is 2.5 parking spaces per room. I see that you really want to cut that down to, what, around 300, 380 or 6 or something like that?
Well, your code, first of all, the code is ambiguous. There's nothing in the code that says for a hotel it has to have 2.5. Nothing at all. So there's a requirement for, guest rooms, there's a requirement for meeting space, a requirement for restaurant. It's kind of an added up. So there is some, some vagueness within the code itself. What we've tried to do is say, what do we really use right now? And what do similar facilities use, on a regular basis? We decided not to put it into the presentation for brevity's sake, but we've been taking photos from the top of the hotel of the parking lot at 3 different times a day, or 4 different times a day, for the last, I think, since May 18th. And the lot's simply not used. Lot 5, the 104 space lot, we have not used once in 2 years. If you've been there, it's blockaded off. The reality is, if you were to build this hotel today and we were to negotiate an appropriate amount of parking, it would be significantly less than we have in the current lots today. And a lot of that, there's a good reason for it. You don't have Uber, you don't have Lyft, you don't have a lot of the, the same types of things that, they exist now. They didn't exist in 1988. And frankly, these types of facilities were relatively new at that time. It was hard to go get a barometer of what reality is. But the closest one that we had, that we were able to identify, and I don't know if you're familiar with it or not, but the Marriott Lincolnshire Resort also has 18 holes of golf. It has, and we've got the one restaurant, and frankly, that's another point. When this thing opened, it had a nightclub, which nightclubs generate a lot of traffic and a lot of cars, or at least used to. Now Uber's, thank God, is dropping the number of people drinking and driving. It used to have where our Hilton Honors Lounge is now, which is exclusively for hotel guests, used to be a 5-star restaurant called Waterford. And then we had the main restaurant, and then there was a salon that was for retail use, and then there was a nightclub. So a lot of this stuff's gone away. So what was planned is different than what exists today. But the Lincolnshire Resort, again, it has more guest rooms than we have. It has more meeting space than we have. It has more restaurants than we have. It also has a 800-seat dinner theater, and they have a total of 1,000 spots, and they don't have a problem. So we looked at that very carefully. Again, we don't want to have a problem here. One thing that also has not been addressed on parking is the ability to, number one, valet, and number two, charge. If you want to reduce parking, start charging. Every hotel, that of a similar caliber, full service hotel with meeting space at O'Hare, in the O'Hare market, charges for parking. And guess what? People figure out a way not to drive. Same thing here. That's what I mentioned earlier. When we're dividing up these room blocks, we're going to mandate that those other hotels shuttle their guests to us to eliminate the parking. So there's a lot of different ways, including economics and supply and demand, to increase the size of the valet field. We think that this main field at 380 is roughly 500 spaces valeted. So we lock this off for valet, charge $10, and fewer people are going to come.
You've just alluded to you've been taking pictures since sometime in May.
Yes.
We've not seen any of them.
That's
Why
true.
not?
For brevity's sake, I didn't want to have 15 slides or maybe 120 slides of parking. I'm happy to share them. What they will show you is that our parking lot is significantly underutilized.
I'd like you to take a look at these pictures, which were presented to us at the last meeting, showing your parking lot is full many times during the year.
Okay, what this picture shows me is a parking lot, or part of a parking lot that has cars in it, which is a good thing. It's a small sample size, taken from the ground.
These were introduced also.
They're not taken from the air like we take them.
These were also presented to us with sworn testimony, which we have to take at fact. Now, you claim
Was the sworn testimony that the entire parking lot was completely full?
That is the assertion that was made to us, yes, correct.
No,
You can check that in the minutes. No.
We would disagree. And in any event, we still have the 104 spaces that I'm testifying has not been used in 2 years.
Your off-street parking. Well, here, let's go back to the hotel. You can keep those if you like. When the hotel was created, the staff created, Westmont created it with, 2.5 spots per room for 965 spots. So you say we don't have a code? No, but that's what we created, so therefore, I would think by de facto, that's our code for hotel rooms.
That's
But
what
also
was-
in, please, let me talk. I don't like to be interrupted. I've been watching Judge Judy. But also, our 2.5 cars per hotel room includes a conference center, includes the restaurant, includes the employees, and the golf course. Now, let's talk about the golf course. I've seen one number in here where I think you're proposing 80 cars for the golf course.
Correct.
18 holes, 72 plus. What happens to the people queuing up for their tee? They're all going to come in individual cars. They're going to have breakfast, hopefully in your hotel. They're going to have a couple of tees queuing up, so it's going to be 4 or 5, another couple of 20 cars. Then after the people finish their golf, they're going to be cleaning up in your showers and et cetera, all while the course is still full. And you're going to have another 4 or 5 foursomes with their assorted cars. I've seen no accommodation to accept all of those automobiles.
So when we, took into account the golf course and with all of our planning, we went to Randy Bolstad, who's been our pro at the course since this course opened, and said, how many spots do you need for the course? And that's where the 80 number came from. We do get a significant amount of carpooling, in particular with league play. We do get a lot of league play, so that's a decent amount. I wish we had a group on every hole. It rarely happens. We also have, when we have special events, I think we max out at roughly 120 golfers is the most we can handle. Given the size of the course, you can't put two teams off a par 3, and we have 6 par 3s. So, we're very limited in the amount of golfers that we can have. And when we do have those special events, in particular in more recent times, and the Robert Crown Center golf event is there a week from Friday, and we've purchased a couple of foursomes for it. And the guys in my group have all been, we've actually got 2 groups that some of my friends have purchased another foursome as well. Everybody's emailing. Are we, who's going to drive there, and are we just going to Uber home? So it's, I've got a Lincoln Navigator. I can get 6 guys in there. It's going to be 6 guys there, and it's going to be there all night. I promise you that. And then we'll all take Ubers home. So it's really a different time. But the 80 number for the golf course came from our longtime pro, Randy Bolstad, who has a tremendous amount of experience.
Also in the parking calculations here, our staff has calculated 280 parking spaces, most probably. Is that correct? I think it's 280.
Correct.
And unfortunately, I don't concur with that. 280, when you're getting 1,400 people in for maximum capacity, you're going to need, that comes out to 5 people a car. Each and every automobile has to have 5 people in it. This is just not going to happen. As best to my calculations, I would come up with around 466 automobiles would be required for the natatorium. As per the residential, we are agreed, you're 505, but as near as I can come up, that I see you insufficiently in parking by around 923 spots, and I just can't. This is a variance that it just goes beyond the pale. There's just no way that I could recommend this anyway. To be quite honest with you, what I feel we have been presented with is a conceptual plan, not a very well thought out planned development or a site plan with all of the T's crossed and the I's dotted. There's still so much ambiguity in this that it's the worst I've ever seen.
What would you like to see improved, sir?
You ascertain that yours is a TOD type structure.
PUD.
Transit-oriented development, the apartment. That was created to be within 1/2 mile of the train station, where people would live and reside in this area. They would be free to come and go to the restaurants and the shops, and we created that very, very much so that we would get people to our downtown. You've taken advantage of that by claiming that you're going to be busing all of these people and they're going to call Uber and the world's going to be beautiful. And these millennials are they're going to miss the bus to the train by a few minutes. And they're going to happily wait for the next vehicle to come and pick them up in another 10, 15 minutes. Or they're going to be late for their dinner appointment and what have you. And then they're going to go in town for their cleaning and their whatever, and they're going to stand there and wait for a bus to pick them while they've got their laundry. I just don't buy it. Our village open space policy. You have used, as part of your open space policy for the apartments, a walking trail, I believe, which is on the golf course property.
It is on the hotel property, sir.
It's on which?
It's on the hotel property.
It is on the hotel property.
Entirely on the hotel property, yes.
Okay. I'm going to jump to one other thing then. You're asking this board to recommend a re-subdivision of the 18-acre parcel into 5 parcels. One parcel will have absolutely no parking whatsoever, the natatorium. Ostensibly, this property could be sold in the future. I'm not even sure that we could legally recommend a parcel without parking that's going to have up to 1,400 people at it. What happens if all 5 of these parcels get sold? You're going to create 5 parcels. The hotel, the parking lot, natatorium, the apartments, and then this future lot 5. Who's going to guarantee that these various entities are going to have access to this? The way I see it, let me finish, is the only way I could recommend this was if there was a recorded easement, recorded on the, at the county office on each lot, which would probably be in perpetuity, that one, the apartment would have access to ingress and egress through the parking lot, its own separate lot. 2, the tenants in the apartment building would have access to that walking trail. 3, the natatorium would have access to use this parking lot. 4, your off-site parking. I'm not even sure if you're ever going to get that past any village. From what I'm hearing, 600-foot limitation. But if you were somehow to get this off-site parking, there again, the Kaufmans do not, if they own, do you own the buildings in Jory Boulevard?
Yes. Yes, we own 2 of them.
Okay.
I personally own 2 of those buildings.
Okay, that's not a problem. Any property that you are using off-site should have a recorded easement on that property. This is only my opinion, I'm not an attorney. That you have the ability to park on that when you need to. Otherwise, an agreement just doesn't cut it.
So on the first several items you mentioned, the common area parking lot will be part of a common area association and will be recorded against the deeds of all the properties. So all of those properties in perpetuity will have the benefit of the shared parking. So I can assuage that concern. In terms of the recording a deed against the property, as I've discussed with staff, from a I understand where you're coming from, and if, if I was advising to protect myself in the worst-case scenario, I'd be in your shoes, but, for example, the Serva building right now, which is a vacant corporate headquarters location, down the street from our office at Oakmont and Pasquinelli, if I went to them and said, hey, I've got an event, in 2 weeks, I'd like to park there, they'd love to have a little bit of revenue for it. And they would, more than likely readily agree. If I said, I want you to record an easement against your property that lets me park there whenever I want, that will take them out of the market for potentially a 24/7 call center, where they need the parking spots 24/7, 365. Similarly, we've had discussions with the school district about parking there, and I'm going to be attending the school district meeting next week. In terms of parking there, when it's Saturday or Sunday, they have nothing going on, they appear to be fine with that. However, on a Friday night, when they have a football game going on, for them to commit a year in advance, and they might have a playoff football game, and record it against the property is very difficult. Furthermore, to record it against the property, you're going to have to go to whoever owns those buildings is going to have to go to their lender and get approval. So your threshold becomes significantly higher. And the example I used at the initial public hearing, for a big special event, and again, this is a couple of 3 times, 4 times a year if we're lucky. What did Medina Country Club do for the Ryder Cup? Did they have recorded deeds?
I really don't care what they did.
But my point is, I guess, that, for the benefit of the community, stakeholders in the community for a special event in other communities have been able to come together and solve those problems before they're contracted a year or 2 in advance.
Okay, understand this. Off-site parking is your problem. It is not the problem of this board to solve.
We agree.
Okay. Secondly, it is my opinion, I don't know anybody else, they don't listen to me too much. The only way to guarantee off-site parking is a recorded easement. Now, all I care about is the well-being of the village of Westmont. If you have a contract and a property gets sold where you were going to park in, all of a sudden Westmont, a couple of years down the road, 2, 3 years down the road, properties have changed hands, parking is no longer available. Westmont is stuck with an apartment building and a natatorium and no place to put all the cars. I live in Westmont, I care about this town, I want to protect this town. I don't want to be loaded with the iffy proposition, we may not have parking space in the future. Now, you ask what would I like to see. I think you could do very well if you put the natatorium, my opinion only, in the space of the apartment building. I would love to see your apartment building downtown, alongside the railroad tracks here, where we've got a lot of land. I'm not in favor of apartments, but I think I could have my arm twisted to OK Apartments to get you downtown and get some people into our downtown area. To call your apartment building up there a transit-oriented district, I just don't buy it. Those are my questions for you. Now,
Thank you, sir.
As I said before, I would like to go back through all the trustees again once you've heard the questions, if you have any further comments, and then we will vote.
Really, my questions and comments have already been answered, and I would just like to say I agree with you about the apartments. My concern is the seniors have bought their houses. They may not be interested in paying rent. I think that if somebody makes $75,000 a year, I'm not sure they could afford those apartments. So those were concerns that I had, and otherwise I'll go to the other commission.
Commissioner Thomas?
I'm ready to vote.
Commissioner Pill?
Yeah, just a few things in summary. First, I love the economic vitality of the project and the associated benefits it brings to our community. There are several. There's a beautiful natatorium, the redoing and the improvements of the golf course that you've talked about, strengthening the position of the hotel through the synergistic relationships. Those are great. There's certainly tax benefits, both property and hotel motel taxes, which benefit all kinds of entities from the school district to the park district to fire, the library, et cetera. I'm also aware of the NIMBY factor. I mean, every time I drive on Route 83 at 5 o'clock, it irritates me when that road narrows for a mile and then goes back to 3 lanes each way. I just hate that kind of stuff. However, after about 9 hours of this and a lot of hours on the side, as I said earlier, I just find that the words don't necessarily match the music. Our comprehensive plan calls for limits on rental housing. And the residents have clearly asked it to decrease. I sat on that committee for 2.5 years writing that plan. Instead, we're increasing from 49 to nearly 53%. You guys have carefully packaged the world-class natatorium as a 2-for-1 and making it a take it or leave it. And I think you're smart to do that, especially based on the comments that we've heard. I would probably do the same thing if I was seated in the front row. However, if I was going to consider voting and approving for this, I would like to see some changes. These are changes that have been discussed several times at different meetings. At the Planning and Zoning meeting and the Village Board meetings on the text amendments, and at several other homeowner meetings and staff meetings and things, several of these were suggested to minimize the impact, the scale, and the number of variances. So my personal issues are with parking, the FAR density, and the look of the project. I'm also uncomfortable with the separation, as I mentioned, into 5 lots. It seems to me like it's a classic case of build, develop, and sell, leaving us to have any of the issues that would be remaining. You defined long-term as 10 years. If it takes 3 years to build this, 3 years to fill it, long-term is really 4 years. And then what's going to happen, and I understand we can go ahead and properly set up relationships so that parking and things like that, I mean, if the apartment were sold and they cut off those 700 spots, it would make it difficult for the hotel and natatorium. You could probably protect that. But I just, that 5-lot structure in the years that I've been doing this usually means that there's impending sales down the road. And while that's certainly your right as a businessman, it's also our right to protect our residents and our community as we look forward. So I have 2 suggestions. These are nothing you haven't heard before. I'll summarize them. The first one is to think about removing 2 stories from the apartment building, thereby decreasing the density, the FAR, and the parking variance. Add to that 2 floors of underground parking. I thought we had talked about maybe there was going to be at least a floor or 2 added. I didn't see that. Further decreasing or totally eliminating the need for parking variance when combined with the first statement. And then I feel that the look of the building, and it's certainly your call on how you want it to look, but I think it's a very stark building with little or no landscape and definition, and I'd love to see it softened up, as in the 3 example photos that were provided from staff, where there's all kinds of different textural, color, and architectural and landscape elements on the outside of the building. That's one idea. That does necessitate reducing a couple of floors. It certainly changes your revenue pictures. The second idea is to build a 3-story garage immediately on lot number 5. This increases the parking variance immediately. Add 2 floors underground, which further decreases it, and then you still have my same comment about softening the stark nature of it. By doing that and staging the project, you go ahead and you set up a situation where you now have additional parking as you begin building the other elements. Because one of the things we haven't talked about here is what happens if you break ground on the natatorium and break ground on the apartment building at the same time. And I've gotten the impression from the discussions we've seen at the meetings that you want to get moving on this. And even with the closure of the golf course in October, that's still not going to take away that many parking spots. I think you're going to have another problem, particularly because you're going to have construction vehicles. And I know you could park on the lot, you could, on the golf course. You could stage off of the golf course because it would be technically closed for a year or more, 1.5 years, I believe you said. But still, putting a 3-story parking structure, and even if you were ever going to do, I think you mentioned an 80-room extended stay hotel, if you were going to do something like that, that garage could be built to already sustain another 2 floors for the 80 rooms. So, you know, those are 2 of my ideas that I would like to see. I believe that some sort of compromise is needed on the record and precedent-setting variances. It doesn't look like the homeowners are willing to budge at all, but I still think from a commission standpoint, I'd like to see some of these things, and I'd also like to see this whole pile of paper cleaned up. Every commissioner has basically brought it up here, and I've had numerous discussions with staff, and we have so many things that conflict with each other. I'd love to throw all this in the garbage and start with a brand-new set of plans. And those would be the accurate, we'd have a list, the PD, so that we could see what the agreements are and what we're actually voting on. It's difficult to actually understand how many parking spots there are. With proper and meaningful changes, I might support this plan in its present state with the submissions before us. I cannot. I would, however, recommend that as the public hearing body for the village board, I think it's important that everybody have adequate time under oath to be able to speak and to have their ideas heard. So I have no problem coming back for another marathon session. I have no problem with the continuance. I would support that. And if some of these things were done, that might sway my vote. If we're going to vote tonight on the paperwork in front of us, which I believe is woefully incomplete, I will not be able to support it. Thank you.
Commissioner Van Buren.
This is the second time that I've felt uncomfortable about doing what I think is right for the village, and I've been here for a while. The first time was in the late 70s, when Jack Douglas tried to put his Chevrolet dealership in the corner of Ogden in '83. And the mayor, Jimmy Wright, came to my living room and begged me to get that thing out of committee and to get it out of the table. It was tabled in order to proceed before the annexation agreement expired. And this time again, I feel that since the 70s, we have recognized that we have too many, the balance of apartment rentals versus home ownership has been way out of kilter. Even after not having put any major or even minor apartment buildings in since the late 70s, or maybe the early 80s, and even though many of those have been turned into condos and have turned over to home ownership, you've heard Greg say we're at 49%. That is not world class. That gives you it takes away your stability as a community. You have children coming in and out of schools, transferring in and out. You have a transiency there that you don't have in a stable community. And for that reason, if you built it downtown, as Eddie said, I would say the same thing. No more apartments. Our balance is completely out. So I in no way can support this, no matter where you put it. Thank you.
Commissioner Carmichael.
This is a tough one. I have to say that after the continuation last month, I really expected when we came back here tonight that there would have been an accommodation between these two sides. Like Greg said, I really expected you to say that you were going to lower the impact or the size to 5 stories, put underground parking. I didn't hear any of that. And as far as parking, I don't know, whatever the right answers, you know, all these estimates and guesses and maybe a little obfuscation, but what the right number and the right size of the parking spaces. I do think that even the off-site issue, you know, parking is problematic at best, and as is the FAR and the idea that or the suggestion that this is a TOD. I certainly don't agree with. I'm also concerned that adding 326 apartments in Westmont would take the community over 50% rental units. And so for all these reasons, certainly at this point, the auditorium notwithstanding, which, everybody wants, but this whole package I cannot support at this point.
My last thoughts is, in the years I've been on here, I have never even been requested to support an FAR of a 0.92 or 93, I think is what we're up to on this. And with the percentage of the variance as what I can best make out of this parking variance, it's just so overboard that there's nothing I can do. I admire Greg Pill's thought on the multi-level parking garage on Lot 5 with the foundation and structure able to support future construction, because I've heard stories that you want to increase the hotel or some other venue there. Also, below a couple of decks of below ground parking for the tenant space would alleviate the parking greatly, and also if by chopping off some of the top of the building, you'd be reducing the FAR, which I could support. Secondly, there were some pictures here that staff presented us with different pictures of apartments. And I can't find it in all this paperwork. I'm looking, that's okay. But if you could see some of the stuff, what staff was showing us, and I suppose I'm going to insult somebody here, but the way I look at the picture of this apartment building, it looks like a monolithic structure, which I think it'd be, when I go down State Street, from 18th Street down to downtown, I see all these types of buildings landing on State Street, and that's what it looks like to me. For a standalone structure, it could be enhanced tremendously. That's all I have to say. Now, let me ask you this. Do you have any desire for a continuance, whether we could absorb some of this, you could absorb some of our thoughts? Otherwise,
Commissioner Pill made some...
I'm sorry.
I'm sorry. I believe Commissioner Pill made some solid recommendations. We are, again, long-term investors, but we're not going to own this forever. And, it's going to be in the Village of Westmont for a long time. We are committed to creating this world-class Westmont development. And frankly, I think it's an anchor for, it'll be a catalyst for the types of things that you want to happen in your downtown. I've talked to staff about, what have you got downtown? It's not an either or. I think once I do this, Westmont has a better brand name, and downtown's more attractive to people, and it'll be a catalyst for that type of development that you're obviously seeking. We're happy to consider, additional parking, whether it's, above ground on Lot 5 or below ground. I'm willing to consider a slight reduction in the apartment building. However, a reduction in the apartment building takes away the economics to provide the residents what I've promised them. There is no, pot of money at the end of the rainbow. So, that's part of what we were attempting to achieve here. The difference aesthetically in a 7-story building and a 6-story building and a 5-story building really isn't that much from an aesthetic perspective. And I'm happy to get recommendations from staff on what they, what they don't like. Candidly, I think it's a great, sleek, modern-looking building. People will disagree about architecture. I tend to prefer to let architects do design and builders build, and and other people practice their own craft. I have a ton of respect for Rick and the buildings he's created for me in the past.
Yes, sir, but you just made a statement where you've been talking with staff as to what they want.
I'm happy to get recommendations from staff, from the plan commissioners, from the village, as to what types of...
But we are the group that has to be satisfied.
Of course. And I would assume that staff would be the conduit for that communication. If you wanted to have a workshop session on the architecture by itself, I'm happy to do it. We want to see this thing done because I think it's great for the Village of Westmont. In terms of the multifamily product, I don't control, a square inch of Westmont besides Oak Brook Hills Resort. I can't control the 49% that already existed. You never controlled it. It was annexed in, as I learned at a
Yes, we
previous
did.
meeting.
It would be 80 now if we didn't control it.
Correct, I agree. This is a different type of multifamily product than you currently have. It's an institutional-grade quality product. What you have now is exterior parking, 2-story, 3-story, lots of buildings, garden-style apartments that don't hold their value as well as something like this does. So I would respectfully disagree as to the characterization of what type of product it is. It's materially different than anything that exists in Westmont today.
And it would go well downtown.
I completely agree. I can't find, a 3-acre site downtown to do a big project. It doesn't exist. And if it does, let me know. I've told staff on multiple occasions, if there's an opportunity in downtown Westmont, I want to know about it. I think this is the, next best thing to happen, not only in the western suburbs, in all of Chicago.
Well, let me tell you what I've been hearing. First off, there was a meeting prior to tonight with the Oak Brook Hill Homeowners Association, and really nothing was resolved. Secondly, the attorneys from Oak Brook Hills Homeowners Association, I thought, presented one heck of a case, especially Mr. Rathje there. But then again, I'm not an attorney. But if there could be a meeting of the minds with some give and some take this time, maybe a delay to next month? Would you be agreeable to that? Or do you want to vote tonight, sir? I'll give you.
No, yes, sir, we're happy to, first of all, get you a clean set of plans so you know what you're voting on. I totally understand that. And furthermore, we can, in a document, get an outline of what a potential PUD and what the obligations on us would be in that PUD. I think that makes sense, so that you have a very clear picture of what you're voting on. In terms of meeting with the residents, we're happy to continue to meet with them. I am not willing to say the apartment building goes away entirely. That is a deal breaker for us. I'm not going to do it. If that is a deal breaker for them, I don't see any reason to meet.
No, I understand that completely, but perhaps your attorney and their attorney talking together, some legal questions were raised.
We'll be happy to host a meeting for the homeowners, their attorneys, whatever would like to meet at any point in time.
So are we going to vote or?
No head fakes, no legal dust.
All right, the opinion, vote for a continuance, Jan, yes or no?
I'll vote for a continuance.
Greg, your feelings?
I would vote for a continuance.
Greg?
I would support that.
I would think that a up and down now would be just as well.
Okay, Doug?
I would have no objection to a continuance if a compromise is possible.
I would entertain a motion to continue.
Before we
Yes.
make a motion, I think we need to talk about a date specific, because if we continue it to a date specific, we don't have to republish. It's my understanding that at the next scheduled Planning and Zoning Commission, there are already 6 items on that agenda, including one major project for an auto dealer. So I think the question is whether we want to convene another special meeting to accommodate this, and if so, if we can agree on a date that meets everyone's schedule, which might be impossible to do, but I know.
Right, we already have some.
John, you might also want to consider reopening the public hearing because there was a motion to close it. So if it's going to be continued to a date certain, just procedurally, you might want to consider doing that.
That would not be a problem at all. No, no. In fact, I would probably go through the meeting with you folks presenting, staff input, and the public comment, and then the commissioners. It'd be run just like everybody get another shot at it. Do we have a date?
Due to staff and commissioner schedules, the last 2 weekends in July are not available, so the earliest would be August 3rd, which would give the applicant 3 or 4 weeks to prepare drafts and still give us time to review them.
I'm out of town, but I'll come back just for that. Not a problem. Okay, I would entertain.
Alaska?
No, not that far. I would entertain a motion to,
Whether they're okay with that?
oh, are you folks okay with August the 3rd for continuance?
August 3rd is fine, sir.
And I promise it won't be long because I'm tired myself. I would entertain a motion to continue.
Before we do that, I think the attorney's suggestion was to have a motion to reopen the public hearing and do that first, and then a motion to continue this item,
All right.
including the public hearing to
Then we
August
don't
3rd.
have to republish.
Correct.
I'll make a motion to reopen the public hearing.
Second?
Motion to reopen the public hearing by Commissioner Pill, seconded by Commissioner Van Buren. Everybody in favor say aye.
Aye.
It's unanimous. Motion to adjourn the open meeting until August the 3rd.
And that's to continue.
To continue.
So moved.
Second.
Motion by Commissioner Thomas, seconded by Commissioner Van Buren. Roll call, please. Let's do a roll call.
Commissioner Pill?
Yes.
Commissioner Thomas?
Yes.
Commissioner Bartel?
Yes.
Commissioner Carmichael?
Yes.
Commissioner Van Buren votes yes, and Chairman Richard.
Yes.